Well, Lordship, tomorrow.
Tomorrow.
Lordship.
Lordship, I would like to mention item number 10. I finally reading it in reply against the detail of question 5 by 2 and the qualification to be the final 28 of this.
Milord, I am planning for listing a matter for motion on Wednesday.
When?
Wednesday, Milord. For motion, Milord. New matter.
Item number 12, I have filed an additional application today, madam. Finally, it will be called for a record, madam.
The pattern, madam, it was fixed on 28. But not this, so it may come on next 4th, Milord.
When
Oh.
it was listed?
It was Milord Padhan. It was listed 13/11 and fixed to start 28. It was fixed.
Thereafter?
It is not listed. On the day it is not listed. So my
When do you want?
3rd, Milord,
When?
3rd of December.
Third.
Next. Online.
9.
Looking about matter tomorrow for motion. Yet finally on Friday.
Tomorrow is hearing day.
Lordship, the urgency is it pertains to need PG 2025. If the authorities are neither granting me resignation acceptance nor anything, the counseling starts from tomorrow. In absence of either two, I am yet to miss another year of my courses. Therefore, I am praying for urgency.
No, day after tomorrow. Tomorrow is not possible. Hearing day.
Because the registration starts tomorrow. If I
Maybe
that is the
Wednesday.
Wednesday.
Yes.
Maybe. May I pay for listing matter or content matter, Mali? It was listed in 2020, 25 for 2025, Mali.
When do you want?
Mali on Thursday, Wednesday, Mali.
Wednesday.
Wednesday. Next week, 12 December.
I just mentioned item number 9, my lord. In this case, today I have received another additional affidavit filed with the respondent college authority, my lord. So I have to give the reply to that, my lord. So, madam, the come after give you, my lord, on 28th of January.
Mr. B. Pokasto, learned counsel for the petitioner with consent from the other side, first for listing the matter after BU vacation. Pair allowed, recess shall list the matter.
On 28th January. 28th January, my lord. Okay. 1 so
Okay.
May I please, your lordship? Lordship, I beg to mention listing two WPC lordship. One is fresh, one is for admission lordship.
Under which column? Under which column?
One is for motion, one is for admission lordship. Lordship, there is urgency. Maybe 4th of December lordship.
20?
4th of December. 4th of December lordship.
4th of December. Hearing day not possible.
On or 8 lordship. Obliged to lordship.
Lordship, I to mention a listing of a fresh petition for motion, Lordship. Can it be on Wednesday, Lordship?
Wednesday. Okay.
Lordship, there's one more petition for listing, Lordship. Can that be on Monday, Your Lordship? Fresh petition for motion, that was for Monday.
Okay. Yes.
Your Lordship. Lordship, I beg to mention for listing, Your Lordship. Similar covered matter already discussed of Your Lordship. Matter regarding non-provincialization of Hindi language teacher.
When do you want?
The matter may be listed on Friday, Your Lordship. 5th.
Friday may not be possible. 8th. Possible. One case.
Admission, hearing. Huh? 9.
Yes.
Published.
This matter was last listed of 5/8/2025 and it will be interim order passed by the honorable court lordship only service on that further respond that has been restored by the order. There is some other because the respondent has been discharging his.
When do you want?
Lordship, next week.
Next week. Take a date from him.
May I please, your lordship? We have filed the IF for the implementation, your lordship. We have kindly to taken up with it, your lordship.
Review petition is listed today,
Or not, yes, lordship.
not listed. When do you want?
Sorry, lordship.
Next Monday?
Yep.
May I please, Lordship? Lordship, I beg to mention listing of a petition, Lordship. Can it be kindly taken on Wednesday or Friday, Lordship? Because the person has been suspended and it's been 10th December. Nice.
To mention for listing of a regulation that relates to provincial license services. Be taken up on Wednesday, Lordship. When? Wednesday. Wednesday, coming Wednesday. Next week, next week.
Items for motion, item number 1.
Yes, Mr. Devi is available. Mr. B. Devi is available.
You know, it's available. I don't have any idea here. I have been surveillance.
After some time,
I may appear.
you may appear. But Mr. Devi was directed to obtain instruction. Is that instruction available with you?
It's not there. So, then I will inform him better.
Yes.
Item number 2.
Please, those kindly pass over for timing notes. Masi.
Item number 3.
Made lordship.
Yeah.
Lord, I take your lordship directly to the page number 26. Petitioner is serving as the, my lord, vice principal of the.
You have filed on a representation.
Yes.
You want the representation to be disposed of.
Yes, and in response to that representation, my lord, instruction has been issued and accept 10 page 28 by the director to the, my lord, director office to the inspector of schools. They have not responded. So my humble prayer is that, my lord, in response to that, they were directed to act upon this, and thereafter following the submission of the seniority list, my lord, the.
Yes, Mr. Siste.
Yeah, that can take.
This is the simple.
Dispose it of.
Yes, sir.
Dispose of.
Only thing is that the seniority list should come from the district office.
Yes.
Only then that the director will.
District
upon.
means from the inspector.
Point that of.
Yes.
Okay, okay. We'll dispose of the police.
And
Obliged, lordship.
apply.
36.
Lord, instruction was sought for.
Yes, I have received after some time. I accept to print out that copy. After some time.
Item 37.
Mr. Fukun, that the original record is available with you.
But the main clarification, which short format.
No. By the order dated 26/11/2025, you have been asked to produce the original record.
That time we were asked to record because the fact that we were not able to, we did not get instructions as per the what is the status clarification. But the clarification has been received by from the department. Second page is the main issue. Because the digital signature was not there, the query of the petitioner counsel was that, my lord, that digital, why was the digital signature not signed? So regarding that, my lord, from the information technology, my lord, second, you know, should see the second page. My lord. There was a downtime going on at that time, my lord. The downtime was going on.
ইউজুয়াল ইনফরমেশন টেকনোলজি ডিপার্টমেন্টে পাঠাইছে ডাউনটাইম হয়েছে ডাউনটাইম মানে আপনার সার্ভার ডাউন হয়ে যায় you can't able to find proper.
Because
Yes, have you seen the instruction? He has
So when I just received it, my lord, I will be allowed to bring this on affidavit. It will be crucial because.
My lord, only one thing,
Because then he can reply out to me.
I don't want to reply, my lord. Only one thing I say, on 12/11, my lord was pleased to ask them to get the instruction. If your lordship looks at the 12/11 order, my lord.
So whether the suspension order was reviewed?
It was reviewed, my lord. The second, we have given the second, my lord, instruction. The council before me, my lord, has given the on record. After that, my lord, the petitioner council raised the query that it was not digitally signed, the last, the review. That part was, my lord, just the clarification. That because of the downtime, my lord, at that point of time, which has been given by the Department of Information Technology, my lord.
My lord, why the doubt arose?
Because, my lord, it's server, my lord.
No, I'm not talking about the server or why the doubt arose. Teacher, she is a suspended teacher. As she approached me, my lord, then I clarified that you first of all make sure that if there is any review or not. Making it certain, absolute certain there was no review, then we approached this honorable court. If this order 4th October, 4th was there, then in the month of November filing this case, my lord, would have been a different turn. When I have not received that 4th order, I did not receive. I was surprised when they produced the order first time in the court on 21/11, my lord, when my lord was asked to get the instruction, they produced this. And then there was a bit suspicion, my lord, that because of this honorable court, now they have woke up. And on 4th, nowadays, my lord, nowadays, every order is digitally signed. My suspension order is signed. Then they gave us show cause, that is also digitally signed. In between this 4th October order, that was not signed. And that plea, my lord, this honorable court on 21/11 asked for the record, my lord, in order to see how this order was passed. Because I informed the court, my lord, that I was absolutely sure that till filing of this case, there was no review. As such, I approached this honorable court. Knowing that there is no review, backing with the Ajay Chaudhary's case, it will go. But suddenly, and this order was marked to me also, it seems, on the, if your lordship has got the 4th order, 4th 10. They have got 2 orders. One is 18/11. 18/11 show cause was issued definitely after my lord's order. And there was a 4th 10 order. In fact, to my instruction, matter was not reviewed till the first week of November. As such, I approached this honorable court. On that ground, the court wanted, by the order dated, the record, my lord. I don't know what instruction they have placed.
By tomorrow, by 2 p.m., you produce the original record. Heard Mr. Abedin, learned counsel for the petitioner.
My lord, should I bring this on record?
Mr. Fokon, learned standing counsel for the respondent in Elementary Education Department. By order dated 26/12/2025, Mr. Fokon was directed to produce the original record. But instead of producing the record, Mr. Fukun has produced one letter of the Director of Elementary Education dated 25/11/2025. Accordingly, taking note of the submission of learned counsel for both the parties, Mr. Fukun is directed to produce the original record before this court by 2 p.m. tomorrow. List accordingly.
Which one second? Deeply obliged.
I think 30th on last occasion, I was directed to in the instruction notice. I have received the instruction notice. Can you give me the detail?
What question is?
Yeah, given was the notice on last occasion when the notice was issued on Annexure 12. All the NIS candidates, they were directed to produce the evidence. But in the notice, that year or date was not mentioned. But as per Supreme Court, also Honorable Supreme Court direction notice, a person of from who got a diploma holder from NIS notice, they have to be in service on as on 10/8/2017. So that was the cutoff date notice. And accordingly, we have modified that notice.
You furnish a copy of this instruction to Mr. Deca.
I submit on notice right now.
Mr. Deca, you obtain instruction and we will list the matter day after tomorrow.
Today is the last day of filing of
Yes.
notice, that dies that are
That
either candidate notice.
Then we will take it up at 2 o'clock. In the meantime, you go to the instruction.
Item 39.
May I please, Your Lordship? This matter regarding non-payment of area salary, my lord. The first time has come, my lord,
Area salary for the period?
for the period.
October 22 to February 22.
Yes, my lord. My lord, it is, my lord, in the prayer, my lord, it is specifically mentioned, my lord. For the month of January and February 2022 and full, my lord, area salary.
Mr. Kaushik, you obtain instruction why this?
Notice be issued. Let notice be issued. Okay. Because we'll have to.
No, no.
By when affidavit. We'll have to respond by when affidavit.
No, that's all right.
But there, they have claimed that partial area salary from January to February. Pursuant to their fixation graduate scale of pay.
Yes, sir.
And October to February 2020.
Full salary.
Full salary.
Well, what happened, my lord, when, my lord, they were, my lord, in the fixed pay, my lord, even, my lord, January, February, they were paid, my lord, fixed pay. But they are, as per their notification, we are entitled to, my lord, enhanced regular salary, my lord. Therefore, partial, my lord, January, February, and full area salary from October to February, my lord. It is mentioned in the prayer, my lord.
So,
And
first,
all the petitioners are from different districts, my lord. Therefore,
different.
whether the petitioners are from different districts. They have jointly filed this petition, my lord. So there is
No, the period is same.
period is same.
Period pay, my lord.
So we'll have to take instruction from all districts, my lord.
Okay, you first obtain instruction, later on, if necessary, we will issue notice.
My-
Heard, Mr. A.M. Barmia, learned counsel for the petitioner, Mr. D. Kaushik, learned standing counsel for the respondent in Elementary Education Department. Madam Yufa,
Fine.
respondent number 2.
Rest I'll appear, my lord.
Oh, Inspector of School also.
Yes. And respond number 4 to 10 are the inspectors of different districts.
The petitioner said in a regret for non-payment of partial salary, partial arrear salary for the month of January and February 2022 and full salary from October 2022 to February 2023. as per their regularization order, struck notification dated 38/7/2022, put in bracket annexure 4, issued by the Secretary to the Government of Assam, Secondary Education Department, Dispur. After hearing learned counsel for both the parties, it is provided that Mr. Fukans, no, Mr. Kaushik shall obtain the necessary instruction and apprise this court on next Monday, 1 week.
1 month. So today I'll provide my supervisor.
Mr. Bormoya, learned counsel for the petitioner shall furnish extra requisite copy of the petition to Mr. Kaushik during the course of the day.
Timing 36.
My lord, may kindly peruse reply 9, 13 and 14. As per my lord, so that kindly reported, my lord, may kindly peruse, my lord, so that first day also. Paragraph 9, 13 and 14.
Yes. Is there any rule in the, no rule?
9, 13 and 14, my lord, may kindly peruse.
Paragraph
When
9.
there is no rule, then also on special circumstances notice, second evaluation was done, Lord.
Hmm.
There is no rule, so despite that, notice second evaluation was done against the petitioner's case. When then also March is 26. Paragraph 9, 13 and Lordship, my lord, may kindly peruse. Paragraph 9, 13 and 14. Two times
Mr. Gogoi, furnish a copy of this instruction to me.
I will furnish it other, I will furnish it.
You obtain instruction? We'll take it up on next Friday.
Lordship,
Friday.
it's a file, furnish it.
Well, can it be on Wednesday? Well, Friday I will not be available.
Next Wednesday.
Next Wednesday.
Okay. Heard Mr. Islam, learned counsel for the petitioner, and Mr. Gogoi, learned standing counsel for respondent in Dibrugarh University. Person to order dated 7/11/2025, Mr. Gogoi has obtained instruction and placed the same before this court. A copy of the instruction be furnished to Mr. Islam during the course of the day. Rest shall list the matter on next Wednesday. So as to obtain instruction by Mr. Islam.
Madam, may be the part of the report.
Yes, the instruction produced before the court today by Mr. Gogoi be marked as Annexure A and be tagged to the record.
Much appreciated.
File number 40.
Your losses. In this case, my lord, petitioner was selected in the year 1999. Then immediately he joined, my lord. And since 1996,
Selected for the post of?
he was getting salary, but before that, my lord, Lordship kindly peruse the court's order.
No, he was
56.
selected for the post of?
Assistant teacher, my lord. School was amalgamated in the year 2006, my lord. Since then, he did not receive the salary, my lord. Lordship, earlier I approached this honorable court, that is page 56, my lordship, last para. However, considering the pair, lordship got it 56.
Yes.
However, considering the pair of the petitioner, his case may be placed before the court-appointed expert committee constituted in terms of the Sudhendra Mohan Talukdar, that is 2006 to GLT 2016, for considering of entitlement of the such salary by the petitioner for his such fictitious appointment as assistant teacher, first as an elementary school teacher under the BSc authority, later on the assistant teacher in high secondary under the inspector of school. Lordship then turned Annexure 2168. Hosai wrote a letter to the secretary to the government of Assam, my lord.
Yes.
Page 68, my lord. With the reference to the subject cited above, I have the honor to state that on receipt of the government letter mentioned above, which reference a report was sought for from the Inspector School NDC Nalbari in connection with the WBC number, and accordingly the Inspector School Nalbari submitted a report along with the enclosure of this matter, white letter dated 6/1/2005. The Ranjit Bormon, that is petitioner, assistant teacher of the Daulsala High School, was transferred with the post from the Kolaguru Vishnurabha High School and was posted at Daulsala High School by then Inspector School Nalbari. Was released with post his pay was not released due to non-available of the government. Hence, his post was adjust against the vacant post of late Chaudhary. Then second para, as per the report of the headmaster of Daulasola High School, Sri Ranjit Borua regularly signed in the teacher attendance register from the date of his joining up to March 2010. But after March, then headmaster issued a separate register for his signature. He has been signing on the register till that. That is their report, my 2025. Till today, they have not, petitioner did not get salary, my lord. Why he has been, headmaster has been taking the signature in separate sheet, nothing is mentioned in this case. Because the petitioner is a selected in the year 1999, man. So my humble prayer, my lord, let him bring instruction and lordship kindly pass an order.
Headmaster is a party, yes.
Yes, my lord.
Yes, yes. And my lord, I have a
No, headmaster
interim prayer, my lord, that
Head-
current salary may be
headmaster will only state about maintaining of the separate register.
yes.
But regarding payment of salary,
I can take instruction.
My lord, I have made prayer, interim prayers. His current salary may be yes, my lord, because the person who has not been received salary long back, my lord, and his situation is very poor condition. My lord.
No incident, maybe, and
Then let them bring instruction on Friday.
I have to bring this.
On Friday, my lord, let him bring instructions.
It will come from Nalbari night.
So what? Somebody you instruction? The person who has not getting
okay,
salary.
next
Time?
Monday.
My
Next
lord?
Monday.
Next Monday, yes.
Or Miss Kedavil learned council for the petitioner, Miss or Mr. U. Sharma learned standing
Hey,
council
where,
for the
send
respondent,
one copy.
secondary education
Right now,
department.
right now.
Then Miss Borua for respondent number PN5.
Finance.
The petitioner herein
Take headmaster.
is agree for
Take
non-payment
headmaster.
of
The
salary
government.
since 1/7/2006 till date. Till date. Miss Devi learned counsel for the petitioner, drawing the attention of the court to the annexure 21 of the petition, submits that
Print a copy of the.
Director, Secondary Education, has written one letter to the Secretary to the Government of Assam, Department of School Education. Stating that the petitioner hearing, assistant teacher of Doulasal High School, was
Doulasal High
transferred with post from Kolaguru Vishnurabha High School and was posted at Doulasal High School by the then Inspector of School Nalbari Bhait, order dated 6/1/2006. And there after the post, after transfer with post, his pay was not released due to non-approval of the government. And therefore, his post was adjusted against the vacant post of late Anjali Chaudhary, assistant teacher of the same school, who suffered demise on 21st of December 2005. And that, as per report of the headmaster of Doulasal High School, said Ranjit Burman regularly signed in the teacher's attendance register from the date of his joining up to the March of 2010. But after March 2010, the then headmaster had issued a separate register for his signature, and he has been signing on that register till date. In that way of the matter, it is provided that Mr. Sharma Learned Standing Counsel for the respondent in Secondary Education Department shall obtain necessary instruction in respect of not releasing the salary of the petitioner with effect from 6/1/2006. And also in respect of maintaining a separate register for the petition. Place the matter on next Monday. Interim pair of the petitioner will be considered after receiving the instruction by Mr. Sharma, Learned Counsel for the respondent in Secondary Education Department. Please take
Hello.
a copy of the
Yes, my lord, I'll
petition
file.
be furnished to Mr. Sharma during the course of the day.
Did
Item 41.
May it please your lordship. My lord, the present petitioner, here, my lord, it has challenged the transfer order at page 23 and Annexure 3, 29/7/25. That transfer order passed admittedly, my lord. The violation of clause of dated 5/5/2023. I don't think first impugn order, my lord, at page 23. District Elementary Education Officer. In pursuance to the approval of the District Elementary Level Committee of the Sribhumi District, the following teachers of the lower primary and upper primary school under Sribhumi District are hereby transferred, rationalized with the post to be below mentioned schools in the interest of the students in the compliance of the Right to Education 2009 as per the provision of the Gov Office Memorandum, that is, my lord, 5/2003, relying on this OM transferred. A subsequent order passed by the memo number pay alliances admissible under rule. All newly posted teachers are directed to report to their respective new places on posting on before 31st July 2025. Further, the concerned teachers must update the profile of the Shiksha, Setu, and so and so and so and so. Very next page, page 24, my lord. Lordship will find at serial number 3030, my name.
No, Mr. Decker,
My lord.
you see, for rationalization of the.
I'll come, my lord. Relying OM, my lord, admittedly they violated the provision of the OM, my lord. I'm being transferred. I'll show your lordship what is in the clause of the OM, that is 5/5/2023, my lord. My name is at transfer order serial number 30, my lord. Hifzur Rahman, my lord. I'm the assistant teacher of 1023 of Pahartal LP School, and I'm being transferred to, my lord, Sarmafa Basti LP School, my lord. That is, then, my lord, where is next date? This impugn order issued on 29/7/25 on 30th, very July 2025, and made an application representation before the concerned officer. Now, before that, taking to the representation, I'd like to show that OM, my lord, page 27, Annexure 5. The relevant operative person, my lord, page 3030. That is clause 4, rationalization of teachers and posts, and 31. The violation provision is page 31. Here I am to close, that is 19 and 21. The 19. While rationalizing in a particular teacher's category, subject-wise, the post junior teachers in terms of the tenure in service shall be passed. Number, my lord, 21. The school education seniority challenge to serve the difficult was the like chair, hill areas, etc. A physically challenged teacher, a female teacher, and a teacher with problems, my lord, kindly be input. Health problems should not be posted in different areas. This teacher should be preferred for posting in the area with better road and connectivity. Now I am agreed for this two provision. They are relying this particular OM, my lord. I am being transferred, my lord. So far as my lord 19 is concerned, my lord, it is said that they have to transfer the junior most teacher. I am the one of the senior most teacher of the concerned school. And 21 clause, my lord. Admittedly, my lord, I have given all
Here is the seniority list.
my lord.
Where is the?
Yes, I have, and
signature?
I, Annexure 9, I will come, my lord. And I'm concerned, clause number 21, my lord. My health, I'm suffering from, my lord, health condition, heart as well as my diabetic condition.
Where
I-
is the medical document?
Yes, I have enclosed here, my lord. My lord, page 32 is my representation. After impugn order received, my lord, very next day, I made this application, my lord. I like to read my representation, my lord. What grounds I have taken, my lord. With due respect, humble submission, I beg to state the right letter dated reference number so and so. I have the honor to state that I have transferred to so school on the cluster Pahartal in the so and so. That, sir, I was a teacher of the others amalgamated by education department by letter dated in the April 2022 and adjusted me with the present 1023 Anno Pahartal LP school, which is too near of my residence, and I have been performing my duty attending in the due time and regularly, so I am going to the school. So I am suffering from various chronic elements, that is diabetes, high blood pressure, and kidney problem, etc. So considering me on the medical ground, I requested you kindly not to transfer me from this school, and there is no road communication to attend the school by motor vehicle, as the result is very difficult to attend the so. In paragraph 4 and 5, I have say 5 and 6, it is 50 kilometers take from my home to there, my lord. Then, my lord, page 33, annexure 7. The level I prefer to the authority. I should.
Mr. Deka,
Yes, my lord.
except annexure 8 and annexure 9.
My lord.
No, annexures, yes, annexure 8. Do you have any other document
Yes, my lord.
to substantiate that you were suffering from?
Yes, listen, my lord. But today morning, I received. My lord, then I may have additional effect. Today morning, I have received some documents, my lord.
Heard Mr. A. Decker, learned counsel for the petitioner. Ms. Ann Fokon, learned standing counsel for the respondent in elementary education department. Mr. Decker submits that today morning he had received some of the documents relating to the present status of health of the petitioner, and he submits that he may be granted some time to bring on record the
And even, my lord, I leave application. my lord.
documents to file. No, to bring on record the same by way of an additional affidavit. PRLO, this is a less than.
Friday can be.
Right.
Item for admission, item number 4, order made.
May it please your lordship?
You have filed your additional affidavit.
Yes, your lordship.
When?
Your lordship on 25/11/25.
From my side, I want to file a reply to that part. The thing is that our instruction has come. The school, because the student taking part in the residential school taking part in the government in the program Gunotsav, that doesn't reflect that the school is provincialized. Notification from the government side has come at 2023, they provincialized the school. And here what is in the affidavit, you see, there student took part. So one part, the government has to give the reply to that, whether any private, anyone can take part in the Gunotsav. Only student taking part in the Gunotsav will lead to, because in their affidavit, in their case even also, writ petition, it is clearly reflected in appointment letter also. At the very same day, because without any procedure, written test, without any interview, only as a private, he was recommended and he was taken. Then agitation was started. Then immediately on that day, it was stopped. So he did not serve a single day.
No.
So now-
You tell me, are you interested to file an additional affidavit?
Yes, Lordship. To that extent, because the government is, and from my side, I just file an affidavit to reply to that part. The taking part will not lead to the provincialize.
Who is appearing for the government for elementary education?
I want to state something. In between, Your Lordship, I would like to say something. Your Lordship, he has said that whether private school by taking participation in government programs becomes provincialized or not. Your Lordship, the thing is that no private school participates or they are recognized as provincialized. That is the fine line of distinction, venture schools and private school, Your Lordship.
Let him
Because-
file the affidavit. Heard Ms. S. Sharma, learned counsel for the petitioner, and also heard Mr. Sharma for respondent number 6 and 8. 6 and 8. Mr. Sharma submits that. So you are appearing for the elementary education, Ms. S. Sutia, for the respondent in elementary education department. Ms. Sharma, learned counsel for the petitioner, submits that person to order dated 13/11/2025. The petitioner has filed an additional affidavit on 25th of November 2025. Mr. Sharma, learned counsel for the respondent number 6 and 8, submits that he will file a reply to the aforementioned affidavit filed by the petitioner and price for granting him 1 week time.
Yes, 2 weeks.
1 week. Whether state is interested to file a reply.
Your Lordship, the school is on Dibrugarh only. Okay, sir, for nine. I will furnish the copy if not served.
Okay.
2 weeks time.
Ms. Sutia submits that she has not been furnished with a copy of the additional affidavit. Ms. Sharma, learned counsel for the petitioner, undertakes to furnish a copy of the additional affidavit during the course of the day.
Yes, today only.
Today. Addresses shall raise the matter on next Monday.
On Your Lordship, kindly on this next week, Your Lordship, because the matter is very long pending.
Pardon?
On 8, if possible on 8,
On
on 8th of this December
Monday. Next Monday.
of last year.
Item 5 and 6. Market maker.
May I take your lordship?
Yes.
The matter pertains to non-payment of area salary, my lord, from 16/10/2015 to 14/7/2022. And the stand of the BTC was that from a petitioner was terminated from service, my lord, and we
Okay,
are reinstated in the service.
you have received the instruction.
Yes.
My lordship, the instruction says that, my lord, the service of the petitioners were regularized on 14/7/22, my lord. Prior to that, my lord, they were working against non-existent, non-sanctioned posts. My lord. So, my lord, their claims were rejected, my lord. And they were moreover terminated from service, my lord, and they rejoined in service, giving the undertaking under the NPS rules, my lord, and they were provided salary from the month of 14 July 22 till date. So since they were working against, their appointments were illegal, my lord, and moreover, they were working under the non-existent post, my lord, so their claims have been rejected. But the fact remains that they have been working since their appointment without salary. Against non-sanctioned posts, my lord, area salary cannot be. You
released.
do one thing, let her file affidavit.
Lordship. Lordship, the first regulation order, my lord, that is in 16/12/10/2015, the page number 36. Where nowhere it was stated that they were regularized in a non-sanctioned post. They kept on dark and thereby they were working, my lord, they joined. And how can it be a person who has understand that they were regularized after termination, after reinstate in a non-substantial post, non-sanctioned post. Accordingly, they were continued.
No,
their
that's all
service.
right. Let her file additional, no, file affidavit in opposition.
Yes.
We'll fix.
Come on after first week of January, my lord.
First week of January.
From 9 onwards, I have to, I'm not available. 3,000, till 15th of December. And
Suggest the date then. Suggest the date.
suggested, suggested that January, no? Huh? Yes, yes. January 2026 of second. 8th of January?
8th of January.
Yes.
Okay. For
The
Ms.
next.
Buzar Barua, Learned Counsel for the petitioner, and Ms. Bora, Learned Standing Counsel for BTC. Ms. Bora submits that she has received instruction. Accordingly, taking note of the submission of Learned Counsel for both the parties, it is provided that Ms. Bora shall shall bring on record the instructions she has received by filing an affidavit in opposition. Accordingly, it is provided that Rest shall list the matter on 8th of January
Yes.
2026.
Numbers 7 and 8.
Actually, the salary by the money.
Yes, Mr. Mahmood,
Yes,
the documents are available.
yes, the other Hafizur Rahman has got salary.
Yes, that order.
My lord, I am giving that order. Right. What the filler is. My lord, only kindly take better after 10 minutes.
Otherwise, I have re-verified. I have re-verified. I've got the accommodation of the Fazlur Rahman as
Hafizur
a
Rahman.
tutor. As a
Yes.
tutor, as a fresh appointee on
Yes.
2021. And he has been receiving salary and a fixed pay based on the cabinet decision taken for the irregular appointees.
Oh, this is what the problem. Yes.
Last page, Melody, is the appointment of 40 Melody.
This is not legible.
Not so, Melody, but I also got a photo.
So you produce one legible copy
Yes.
after some time?
Yes, my lord, I have got. I have got.
Yeah. The same appointment. He has been accommodated as a tutor pursuant to the decision that is been taken by the cabinet, my lord, in respect of the irregular teachers who were screened by the screening committee constituted by this honorable court, my lord, in Manoj Kumar Sharma's case. And this fixed pay, my lord, is the prospective in nature. Your lordship see down below the table, my lord. The accommodated tutor will get the prospective effect from 1/11/2020 only, and she cannot claim any benefit whatsoever in respect of the services rendered by him post prior to 1/11/2020. So basically, my lord, he has not, the petitioner, my lord, has not disclosed this thing, my lord, that he also had subjected himself to the verification process that was undertaken by pursuant to a direction of this honorable court in Manoj Kumar Sharma. And in that manner, the cabinet has taken a decision in respect of those irregular teachers, where they will be accommodated as a tutor in a personalized post and the fixed pay would be prospective, my lord, without any past service.
Lord, actually,
And in respect of the other petition, my lord, Solimuddin, my lord, apparently as I have argued, my lord, last day, that his position in that list was above 82, 160.
And Hafizur Rahman
Hafizul was within 82, and therefore
within
he-
82.
48. He was 48, serial number 48, and Hafizul therefore has subjected himself to the verification process.
No, Mr. Kaushik, do you have any document to show that only 80 posts are sanctioned for the district of Bangladesh?
In the order of this honorable court itself, my lord, it is there, and page 43, the speaking order.
No. 40?
Page 43.
No, there only it is mentioned that only 40 posts are sanctioned
82.
for the
82.
or 82.
And all these 82 posts were accommodated, and they have been given.
Page number?
Page 43. 43, WBC 7058. Last paragraph.
So whether this letter is available with you?
Which
Letter dated 6/7/1994. Mentioned in the order.
I can get it.
No. You see the sentence. The name of the petitioners, namely Hafizur Rahman, Abdul Rashid, and Solimuddin, appeared in in serial number 106, 169,
360.
and 360 respectively.
Solimuddin was in 360.
Yes.
Now Hafizur, my lord, got what he did, my lord. He did not claim for a salary, my lord. In this reparation, he did it, but pursuant to that advertisement in Manoj Kumar Sharma's judgment, my lord, the division bench appointed a screening committee for verifying the claim of salary and the service. In that regularization process, in the verification process, he applied. And he got his accommodation now in 2021 pursuant to the decision of the cabinet, my lord. So he has abandoned his claim in respect of his appointment earlier. And with all respect, my lord, nothing has been pleaded in the repetition, my lord. This repetition deserves dismissal on the ground of suppression. But actually, not even the order that was passed by this honorable court, where this honorable court has determined their right of regularization, saying that these appointments were absolutely in violation of the statutory prescription.
Okay, we'll see.
Lord,
Mr. Mahmood.
what my learned friend said, Hafizur Rahman did not disclose about getting salary. Actually, I have got this fresh appointment letter in the year 2018, and I filed the writ petition in the year 2017. So disclosing that matter does not arise. And so far, I did not go through the screening committee, my lord. It is absolutely incorrect. The other day, the day before yesterday, I was called by the DO Bongaigaon that what documents you are possessing, perhaps some order has gone to him. So I have produced all these papers and he was satisfied.
He was?
All these papers. The DO asked me to come with relevant papers and he went there with all these papers. And all these matters have been also deposited before the DO. Whether it is communicated to my learned friend or not, I do not know. I am telling about Solimuddin.
Item number
Please, let me finish. Now my learned friend is saying that my position, then Lordship may kindly see the provincialization order. That is, my lord. Page 16. Page 16 is a provincialization order, and my lord would see my name appears at serial number 118, page 20. This is after several communications, several scrutinies. This order was passed. Now kindly see page 20. My name, Salimuddin 118, serial number 118. But this 123, Tulsi Burma, he has been receiving salary. And I have also annexed his salary slip here. So my learned friend says there are 82. These are imaginary or concocted to get rid of paying my salary. Kindly see page 58.
Page number 50.
Page page 45. Kindly see. This is Finance Department's letter. Page 46 of 40%, Tulsi Burma. So his serial number was 123 of the regularization order. Just now I have shown the
Okay,
regulation order by director, my lord. His serial number is 123 and they have paid him salary, and my serial number is 118, and I have gone through all the processes of scrutinies. I have given the letters day before yesterday, so I could not file these papers to additional affidavit because yesterday the client came and today case was dropped. So even one person, my lord, her name was also not there in the list. That is, kindly see page 58.
No, the other day you have pointed out all these things.
The argument was concluded.
No, he's saying that I have not concealed anything. I have, at that time, what was available within my knowledge, I have disclosed. No, later on something has gone. How I can say?
Well, in fact, the 2021 order, Miller, this order in item 13 and 14, if your lordship finds, Miller, the same order is put to challenge in a different repetition. This order is pursuant to a cabinet decision, Miller, where your lordship will find that from the contents of that order, it's similar order, sir. Item 13 and 14, your lordship can tell you that this is pursuant to a screening process done and a decision taken by the cabinet.
My lord, one most important thing I am drawing your lordship kind attention. Kindly see page 30 of this Salimuddin's case. Page 30. Here several pictures filed writ petition, including Salimuddin and Hafizur Rahman, and some others also. As we are two, so I am mentioning these two persons, Salimuddin and Hafizur Rahman. What is the court order? Lordship may kindly see page 31. Bottom. Having heard the learned counsel for the petitioner and learned counsel for the respondents, I am inclined to dispose of this contempt petition by extending the period fixed in the order dated 16/3/20 for its implementation by a further period of 3 months from today as an outer limit, provided no appeal is filed by the respondents and no stay is obtained of the order impugned therein. In other words, if no appeal is filed by the respondents and if filed and yet no stay is obtained, then order that is 16/3/20 passed in WBCN number 143/2009 shall have to be complied with in letter and spirit by the respondents within 3 months from the date of this order. In case if the order is not complied with, even within the extended period, fixed period fixed by court, subject to what is discussed above, the respondents and all other authorities responsible for ensuring compliance shall be held guilty of committing contempt of court order and appropriate orders imposing punishment as provided under Contempt of Courts Act would be passed against each of them. So, my lord, this order, very strict order of the Honorable Court, and no appeal is filed, no issue is obtained, and pursuant to that, Habibur Rahman has got the salary. So, when the order is not challenged, it has become finality. So, how the order of the court can be frustrated by producing various letters? Order of the court must prevail over the so-called subordinate orders, legislation or guidelines thereafter, if met. So, this order is not under challenge. No appeal is filed by them. No stay has been, so when appeal is not filed, stay matter does not arise. So, what they want? They cannot frustrate the order of the Honorable Court by bringing this and that. And this order is passed, we have been appointed in 1994. So many scrutinies going on thereafter, our service was regularized. Now they are saying this and that. So I think, my lord, I should be paid my salaries. First, another thing, if I am provided the salaries or the remunerations like a tutor for the time being, I have no objection, because since the 19 years, I am serving 19.6 plus 20, 29 years. If I am appointed as tutor and paid the remunerations which have been provided to the tutors, that lordship may kindly pass. So far our area salary is concerned, for that we may file a separate case subject to advice of the client. This order is enough. Nothing is required.
So, Mr. Kaushik, no appeal has been preferred against the order.
Pursuant to this is the order in the contempt proceeding.
Contempt proceeding.
And in the main order where the direction was
No,
given.
against the main order.
Yes, against the main order. In the direction that was given in page 28. Page 28, my lord, this honorable court directed the commissioner secretary to take necessary steps, and also, and for that purpose, were directed to, given a liberty to make an inquiry. And pursuant to that, this speaking order has been passed at page 41, which is the subject matter of.
Where liberty is granted to inquire the matter?
As directed, the commissioner secretary would cause to take necessary steps so that area and current salary of the petitioners are released. And for this purpose, whatever inquiry is required to be done should be done by the authority. And page 41 is the order, my lord, after examining the claim of the petitioner, my lord, in respect of salary, and this speaking order has been passed, my lord, pursuant to the observation that has been the decision that has been taken by this honorable court in WPC 2346 of 2008, based on the judgment of this honorable court of 85/2013, which, my lord, though the petitioners were a party to this petition, has not placed this judgment in the petition. And this order is passed prior to filing of this petition. And if you're
No, Mr. Kaushik, you see, in this order, you have not given the option to disobey the order of the court.
No. For the purpose of giving the salary, my lord, we have been directed to make inquiry by the authority, keeping in mind the facts as indicated above in this order. Now, this is 41. If your lordship will see, it is a, there's no fault in the decision making process that has not been pointed out also. In the speaking order, my lord, the commissioner and secretary has taken note of the judgment of this honorable court at 8/5/2013. The other day, my lord, I read the 8/5/2013 entire judgment. Your lordship has seen that.
No, no, Mr. Kosek, you say direction was to pay, to take necessary steps so that the area and current salaries of the petitioners are released.
And for that purpose, make an inquiry.
For releasing the area and current salary,
Yes.
for not releasing the current area and
We have
salary.
rejected the
Current
claim.
areas are,
The claim has been rejected by the speaking order saying that they are not entitled for regularization. Their regularization has been rejected.
no, or direction was for payment of area and current salary, not for regularization.
No, my lord, you kindly see the first page 26, my lord. Under what circumstances this order was passed, my lord? And therefore, this honorable court has given us the direction, commissioner was directed to make an inquiry because there was nothing on record on the page 26, second paragraph. Subsequently, the pleaded facts which have not been controverted, the respondent and the petitioner were initially appointed as so and so, passed by the district court in terms of the said respondent petitioner joined in their respective posts. Subsequently, however, a screening committee was formed by the department to know the legality and the validity of the appointment of the candidate. And upon such services, 125 teachers were regularized. Accordingly, they were regularized in their services. The names of the petitioner find place at serial number 22. Now, my lord, you can see the last paragraph. As indicated above, in spite of granting sufficient time to obtain necessary instruction and to file counter affidavit, the education department preferred not to file any counter affidavit controverting the allegation made by the petitioner in the petition. However, the counter affidavit has been filed by the finance department and is taken by the finance department as submitted by so and so. Has no objection in issuing necessary sanction for payment of salary to the petitioner, provided.
Okay, we'll see.
And if your lordship will lordship wants to tell you what is this, one of the order of accommodating and tutor, lordship can see item number 13 and 14. Same order which was pursuant to a verification by the screening process and decision of the cabinet.
Okay.
My lord,
Mr.
one reply, my lord. My learned friend has said regulation.
Okay, all right.
So it is there in the order itself.
Person to order dated 25/11/2025, Mr. Mahmood, learned counsel for the petitioner, has produced the order of payment of salary to one Hafizur Rahman. It is to be noted here that by order dated 25/11/2025, the argument of both the parties have already been concluded. Accordingly, the order stands reserved.
Even my lord, this present position, we as BLO, we have been deputed
Okay, next item.
for helping the BLO.
As I was saying, sir. Any items? Item 1, promotion.
Mr. Devde, the instruction is available with you.
Yes, your lordship was pleased to put the instruction that whether the matter when placed was considered in all other departments or not, your lordship. This particular matter, your lordship.
You have received the instruction.
Yes, I have received an instruction, your lordship. This is very
So whether it was placed before the, no, whether the DLC has considered in respect of the vacancies in other department of the district.
Lordship, Lordship may peruse page 27 of the read petition. So what in fact it transpires is that your lordship, all the heads of the departments, they used to be present in that particular DLC, your lordship.
You file an affidavit?
Lordship, otherwise, your lordship, the fact is that both of his parents were service holder, your lordship. In 2006, the father expired. Then in 2013, the mother expired, your lordship. She preferred the application in 2014. Her application was placed in 2015. Her application was placed in 2016. And in 4 instances, her application was placed, your lordship. So, not even, she has not even annexed the next of kin certificate, whether her other next of kins are there or not, whether. So, that it would be ascertained whether.
No, Mr. Devi, the direction of this court was very specific. While the DLC has considered the matter, whether they have considered the case of the petitioner in respect of the vacancies in other departments or not.
So, that context, your lordship, that page 27, your lordship, all of the departmental heads used to be there, your lordship.
That is there, but whether you have considered the case of the petitioner in respect of the vacancies in other department, whether the minutes of meeting is specific in that regard. No.
To that, so your lordship, if the petition remains pending for due to want of vacancy for 2 years, your lordship, that cannot be entertained again, your lordship. That once it in that.
Okay, you file an
Yes,
affidavit.
yes.
May I please, your lordship? For my learned friend is saying for 27, my lord. It clearly says, my lord, for verifying the department. All the department, my lord, may I read, my lord? He asked the heads of the department to verify all the documents, my lord. This is just a format of the my notes that it is written in every minutes of the meetings that verify the records. The heads of the department is requested. It does not imply that my case was referred or considered in any other department. In this context, my lord, I would like to give us for a coordinate bench order, my lord. For our in our high court, my lord. This view was taken that, my lord. And my lord, I have taken specific instruction from the petitioner, my lord. Her case was not placed in any other department. She has said, I have been told, my lord, that. And 4 occasions, my lord, my case was before the DLC. And due to non-availability of the vacancy, my lord, I was not considered, my lord. So my lord, it is a clear case. I have all the DLC, my lord. So can it be like this, my lord? My lord may direct the respondent authorities to consider my case fresh in the next DLC. If vacancy is not available in this particular department, then my case may be considered in any other department if that advice, my lord.
No, they have taken one stand that your case was not considered on account of lapse of time.
No, thereafter also, my lord, in 17, again, my case was placed before DLC, lapse of time thereafter, my lord. Again, the want of vacancy is written, my lord. My lord may see, I have annexed that. 17.
Page number, please.
Yes,
Page number?
my lord, I'm saying.
That page 31 perhaps. Page 31.
31 is on
Sorry.
account of
Page 31. Your Lordship.
lapse of time.
Serial number 6.
Yes, that is,
If that be so, what she has done after 2017,
My lord,
she
because I,
did it for 8 years, she had said, Your Lordship.
no, my lord,
That is
because,
what the questions have arisen.
no, my lord, because I have been,
After, her father's, said mother was there to look after her. Her mother was also a public servant. And after her mother's demise, until 18, she availed the benefits that is, that are given, Your Lordship. And now that she has not even annexed the next of kin, Your Lordship.
so I have stated, my lord, I am the only legal here, my lord. I have stated in my writ petition, my
Or,
lord.
Your Lordship?
After my mother, I am the only legal here, my lord. I have stated specifically in my writ petition, my lord. That is not in dispute, my lord.
After 2017, if there
Lord,
are
I am-
instances, Your Lordship, that she has tried or made an effort and that it is in need for her, Your Lordship.
My lord, because I was told by the department that if there is a, there will be
That
any
cannot be done.
vacancy, I'll
There are
be.
so many answers in that field.
So my lord, I am praying for the similar order. I have just,
so when the claim of the petitioner was last rejected by the DLC,
my lord, in page number
2016?
the 33, my lord, annex of 5, my lord,
2017.
17, my lord.
2017. Where her name appears?
My lord, I'm,
33?
Page number 34. Real number 33, Your Lordship.
33.
Not recommended.
My lord, 33, my lord, page number 33. Not recommended, want of adequate vacancy, my lord. This is after time left, my lord. The next DLC, my lord.
Lordship, that one annual income column is shown, Your Lordship. Annual income column, Your Lordship. That those all criteria also matters, Your Lordship.
My lord, no,
No, Mr. Devri, the question is the remark. There it is stated that not recommended due to want of adequate vacancy. So whether the question is whether her case was considered in respect of the vacancies arising in the other department of the district.
Lordship, when the DLC sits, the entire, all the departments, they sit together. here. So vacancies of all other departments are known to them. Your Lordship.
All the head of the
It is
department,
not, it is that candidate for one particular department do not exist. Definitely they will engulf with the other, Your Lordship, persons from other departments. It normally, it goes, Your Lordship.
better you file your affidavit, we'll say. Today we will issue notice. Art Ms. Zia, learned counsel for the petitioner, and Mr. Devri, learned standing counsel for the respondent. Respondent number 1 and 3.
I'm for 3, Your Lordship.
3. Mr. Bora for 1, 2, and 4 and 6. 4 and 6. Mr. Devri submits that he has received instruction pursuant to the order passed by this court on
10/11/2025. Accordingly, it is provided that Mr. Devi shall bring on record the instruction received by him by filing an affidavit in opposition. Further, it appears that while directing Mr. Devi to obtain instruction by order dated 10/11/2025, notice has not been issued. Accordingly, it is provided that notice be issued to the respondents returnable on next
December.
15 December. 15 December. However, no formal notice is required to be issued since all the respondents are represented by their engaged counsel. However, extra requisite copy of the petition will be furnished to them during the course of the day. List the matter accordingly.
Lordship, that the petitioner bring the next of kin into record. It is an essential document which is required.
We'll say first day file your affidavit, we'll see.
Next of kin by the next day of kin, Lordship.
Yes, is it available with you?
Yes, ma'am.
Okay,
I can bring it.
okay. Further, taking note of the submission of Mr. Devi, it is provided that the petitioner shall also file an additional affidavit bringing on record the next of kin certificate issued by the Deputy Commissioner. Who issued the
That I have to, my lord.
Deputy Commissioner?
That I have to take instruction, my lord.
Okay, by appropriate authority.
Coming item.
Obliged.
For motion.
My lord, on the last occasion, we are directed to obtain instruction regarding chapter 5, my lord, at page 28. This is the representation submitted by the petitioner to the principal secretary, education department, my lord, regarding, my lord, prayer for cancellation of government school who are allowing the student of the non-permitted and get their registration. My lord, in this regard, my lord, kindly see annexure 2, my lord. 25, page 25. It is the letter from issued by the Director of Secondary Education to the Inspector of Schools. And I am reading the quoted one, my lord. Many schools which are not affiliated to SEBA and do not have UDIS code are registered their students in class 9 through government or provincialized schools or other affiliated private schools. But such students are not actual students of the schools where they are registered and can be termed as fake students of the registering school. Such activities have created problems in monitoring the performance of government or provincialized schools. Accordingly, it is suggested that such unhealthy practices adopted by many government provincialized schools be stopped by issuing suitable instruction. And my lord, after following this instruction, my lord, next page, my lord, page 26. This is the instruction issued by the Inspector of Schools, CDC Silchar, to all head of institutions. I am reading, with reference to the subject I would like to inform you that no students of class 9, 11 of non-government education institution, private school, without taking permission from the Director of Secondary Education Assam, and also without having Assam State School Education Board SF Division 1 school code or Division 2 school code should be registered under SF Division 1 of your respective school. If any school found registering such students under SF school code of their school, the name of the school shall be forwarded to the Director of Secondary Education for cancellation of permission, and also SF for cancellation of the school code and other disciplinary actions shall be initiated against the school. And now the steps should be taken up by the Inspector of School.
Inspector of School seems has already taken the steps, has already informed the head of the institution law. And he said whether he said every institution, whether they have informed or not. So they have to be partly in this. petition law. Because inspector school is there sitting in the district capital law. So he has instructed all the private schools, all the schools, not to do, not to act, not to register, all the things. Now, whether those schools, whether they have acted upon this or not, it's a bit difficult to answer law. Until that, they need to inform to the inspector of school law. And whatever the institutions are there, I think they have made parties. Yes, notice should go, they have made parties also.
Notice may issue, my lord, we will file everything.
They have made parties, all the respondents are there, private respondents are there. So let them come and inform this honor to court, whether they have acted upon the instructions by the inspector of school or not.
So notice has not been issued.
They are all public schools.
No, notice has not been issued till date.
Yes, my lord. Notice.
Let notice go there.
Yes, notice.
Yes, sir. Heard, Mr.
H.L. Ashram.
Learned counsel for the petitioner, Mr. D.K. Roy, learned standing counsel for the respondent in
5, my lord.
5.
5.
And Mr. Sisti for respondent.
1, 2, and 3. 1, 2, 3. Then proceed. 6.
1, 2, 3,
Six,
and
then
6,
Then 9.
9,
10. 10.
10,
Yes, no.
9, 10. Spoken for respondent number 8. Ms. Borthakur for respondent numbers 6 and 7.
No, 4 and 7.
4 and 7, okay.
Yes,
4 and 7. Person to order dated. Where is the instruction?
My lord, this is the only instruction, my lord. I have submitted, my lord, before it's honorable court.
When?
My lord, this instruction is already, my lord, that document annexed in the writ petition. my lord.
Okay.
Yes, my lord, have it.
Mr. D.K. Roy, learned standing counsel for ASSEB. Comma, person to order dated 21/11/2025 has obtained verbal instruction and submits that said instruction has already been placed on record by the petitioner as annexer number.
Annexure 2 and 3, my lord.
Annexer 2 and 3. Annexer 2 and 3. That this is this, Mr. Sisti, learned standing counsel for the respondent number so and so submits that the inspector of the school Bhairis letter dated 24/3/2025 annexer number 3 has already instructed the principal stroke headmaster of the schools
When 11 to 19, my lord.
for cancellation of UDAS stroke, UDAS code stroke, SEBA code, and also other disciplinary actions should be initiated against the school. Who have admitted non-government educational institution within private schools without permission from the Director of Secondary Education Assam and without ASSEB Division 1 stroke Division 2 schools code. And those principals and headmasters have already been arraigned as a party in this proceeding. And at this instance, notice may be issued to them so that they may file their response in this petition. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that notice be issued to the respondents returnable in 2 weeks.
Yes, ma'am.
State upon the respondent number 11 to 28 be taken by registered post with AD and also by usual process within a week from today. Additionally, dusty service is also permitted. After effecting service of notice by dusty mode, the petitioner shall file an affidavit before this court. And no notice is required to be issued in respect of the respondent number 1 to 11, the 1 to 10, since they are represented by the standing counsel. However, the requisite copy of the petition will furnished to them during the course of the day. List the matter on 18 December. In the meantime, the state respondents may file their affidavit in opposition.
Most obliged.
Sir, in this case, my lord, while provincializing the service of other teachers lordship, the Arabic teacher was not my lord considered lordship. And policy page 26, the application submitted by the headmaster for provincialization lordship.
Mr. Ahmed, whether they have filed their affidavit?
No affidavit.
Here, my lord, petitioner has filed a representation report of the secretary. That fee, my lord, the section 14 of the act.
Page number?
Page 39.
39.
Annexure 11 law.
15 under section 15 of the act, my lord.
So this has not been disposed of.
It may be directed to be disposed of and directed to be considered.
By
lordship
on
as per
speaking
my lord-
order? Within a period of
as per my
2
lord-
weeks from today?
2 weeks.
3 weeks. 3 weeks?
Further consideration may be directed lordship as per my lord similar order passed by this honorable court lordship in many cases of the analogous petitioners lordship. To consider lordship.
No, if the direction is to be issued only for disposing of the representation.
Appeal, that is appeal under
appeal.
section 14. But here in the city, no, my lord, appeal was not there, my lord. Directed to consider their cases, lordship.
Here, file an appeal, my lord. You can direct the secretary to dispose of this appeal.
Dispose of and consider lordship. Okay, no problem.
Okay, next item.
Oblige, lordship. Appeal, lordship. Lordship on 17/9/2025. It's on for first order. In the rest to produce entire file on what basis the junior one has been provincialized. In the case, my lord, the respondent number 6 and 7 are junior, and so far respondent number 6 is concerned, his name appear in the Daesh court, but 7 name has not been appear in the Daesh court. Even they have been provincialized. Therefore, this provincialization order, relevant portion is challenged before this court. And they has not failed to produce the. And I have also filed reply, my lord, so far affidavit opposition filed by respondent number 2, which is on record by requisition. Now, my lord, the issue involved, my lord, so far section 2 subsection small ZA is concerned of Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institution Act 2017. Here, my lord, it is clearly said that with mandatory provision, but my lord, the 2009-10 Daesh Code mandatory. And here, my lord, petitioner before lordship, their name appear in the Daesh Code 2009-10. That is page 30, madam. So this is the issue, my lord, and ratio decision. In page 30, the petition number 1 name appeared, my lord, under serial number 3, but here written as 4, Muhammad Baharul Islam, petition number 1. And petition number 2 name here, Muhammad Noor Abedin Mondal. And respondent number 6 name appear under serial number 7, Sheikh Hanifuddin. And respondent number 7, Shanur Uddin, is not appearing. Even though, my lord, this Shanur post has been provincialized as a tutor. And therefore, my lord, the coordinated bench of this whole court passed the order that 8/11/2021. This is right order passed. 8/11/2021. Their
Page number?
order, my lord, 8/11/2021 on record, man. This order passed.
Yes.
My lord, last portion, my lord, I am reading.
Hmm.
That 2 further teachers who were provincialized are respondent number 6, Sheikh Hanifuddin, and respondent number 7, Shunaruddin. Shunaruddin was appointed on 1/3/2010, and Sheikh Hanifuddin was appointed on 20/1/2006. Whereas the petition number 1, Muhammad Bahar Islam, was appointed on 1/1/1998, and the petition number 2, Muhammad Nur Abdin Mandal, was appointed on 28/3/1993. In the NC Customer Ami Madrasa, as the 2 additional teachers were not provincialized against any specific subject, and the 2 petitioners being senior between the 2 teachers who were provincialized, a prima facie case has been made out. Considering the balance of convenience and irreparable loss that the respondent number 1 may suffer further effect of provincialization be not given to the respondent number 6, Sheikh Hanifuddin, and respondent number 7, Shunaruddin, until further order. My lord, against this order, they also challenging by filing IA under Article 226 3, my lord. This not maintainable even. And so far, my lord, the stand taken by this petitioner.
So, this annexer 7. Annexer 7.
My lord, here, my lord, relevant list, and here, my lord, top below, my lord, name shown Shunaruddin, my lord, respondent number top right side, my lord. Against NC Customer Ami Madrasa, actually, he is not eligible candidate. His name not appear in the dice code 2019. And another, my lord,
Oh,
this
where the name of the petitioner is reflected?
petitioner name not appear, my lord. This is the provincialization list, my lord.
Annexer 7.
Yes. This is Shunaruddin, respondent number 7.
Hmm.
And next page, my lord, page 35. My lord, one top, Sheikh Hanifuddin.
Hmm.
Page 35, top right side, my lord. Sheikh Hanifuddin, respondent number 6.
Hmm.
His post also been provincialized, but he is far junior to me.
So where is the seniority list of the school?
This,
Page number?
my lord, is 30, my lord. It is as per dice code, school dice code number shown,
Hmm.
year 2019, name NC Customer EM. And here, my lord, petitioner name appear under serial number 4. Eventually, it should be serial number 3. I have got a mistake.
Hmm.
And petition number 2, Muhammad Nur Abidin next, and Hassan Nurul Islam and Sheikh Hanifuddin. He is the respondent number 6. His appointment, my lord, on date of joining 2006. But petitioner joining in the year 1998.
So the
88.
name of the respondent number 7 is not reflected?
Not
This,
reflected in this case.
Okay.
Because he is not entered on the dice code. Subsequently, he was appointed. But when dice code issued, so far the dice code number in the year 2019, and this is attracted, my lord, so far section 2, small ZA of this act, 2017. This is mandatory provision. Without appearing the dice court, that he cannot claim he is not eligible, my lord. And even though the bypass,
So where is the resolution of the district scrutiny committee?
resolution I have not brought, my lord, but this is the dice code, and subsequently, my lord, another list that is, my lord, educational and professional qualification of teachers, tutor, page 5.
Page?
Page, my lord, 31 and extra 5. This is, my lord, type copy, and this is original copy, next page. Here, my lord, petition number 1 appear Muhammad Baharul Islam, serial number 3, and Muhammad Nur Abidin Mondal. These 3 and 4 had been left to Quran's list. And 5 Hassan Nurul Islam, 6 Sheikh Hanifuddin, and here Shunaruddin Nam also appear, expert numbers in the serial number 7. So 6 and 7 being Quran's list. By overlooking this prima facie case 3 and 4.
Okay.
And there, my lord, date of joining also clearly shown. 10, petition number 1 joined on 10/1/1988. Petition number 2, 28/3/1993. And Sheikh Hanifuddin, 21/2006. And Shunaruddin, 1/3/2010 to New York. About their date of joining. And what basis these 2 persons, that number 6 and 7, appointed as, sorry, lordship, provincialized as tutor.
So
Therefore,
respondent
this
number
also
7, respondent
ask the
number,
respondent seek to.
Mr. Bhuya,
What is the entire?
this respondent number 7 is the science teacher.
No, respondent number 5 is the science teacher. And 7, Shunaruddin is the art graduate, TDC arts.
No.
This
He
is the
used
name
to-
of subject taught on the.
Yes, he used to teach Assamese and science.
Yes. But there is a science teacher also available, my lord. One, my lord, Hassan Nurul Islam, under serial number 5. He is science graduate. And here says as a teacher. So far, dice code is concerned, they are appointed as teacher. That means they are teaching all subjects. Here, my lord, saying under category 3. Category 3 means, my lord, they are teacher. And they are teaching all subjects. So far, appointment on subject, the dice code, appointment on subject number 1. 1 indicates all subject. Subject they can teach. This is the upper primary school.
Yes, anybody for the respondent in elementary education department? Mr. Kosak, you have filed your affidavit?
Well, yes, madam.
So what is your stand?
But the stand of the director, madam, is that the district school level scrutiny committee recommended, as per the, based on the enrollment position, has recommended the name of 4 teachers. Surman Ali Ahmed, Hassan Nurul Islam, and Muhammad Jalilur Rahman, Sheikh Hanifuddin. And after the proposal was received by the district scrutiny committee, it was placed before the state level committee. The state level committee, further upon verification, has found that these teachers.
That is district scrutiny committee's resolution is enclosed
No,
with
it
your
is not.
affidavit? Page number?
That is not an. Neither in the dictation of the fraud by the Indian.
And the minutes of the meeting of the state scrutiny committee, that is also not enclosed.
Yes.
So can you enclose those 2 documents by an additional affidavit?
Pilot, I can bring it.
Because unless the resolutions are produced before the court, we cannot adjudicate the issue.
That's what, and the challenge in the retribution is the provincialization of them.
Yes.
And that is based on these 2 recommendations.
2 recommendations.
Gotcha.
Mr.
I
Bhuyan?
filed my lord reply, but that whether any recommendation was there, it was not communicated. And on what basis the senior one has been declined.
No,
That's not-
therefore,
Nothing disclosed.
therefore, let him produce the
Yeah.
two resolutions.
Therefore, my lord, this honorable court part of 79 to produce entire file, but
No, that is there
that failed.
on,
Huh? Order আছে 17/9/2025. There is an order.
To file our affidavit and to bring
No,
on.
no,
board.
also their direction to produce entire file.
so there is a direction to produce the entire file.
Yes, Lordship.
You produce the file then, instead of filing the,
Original record
yes, original record.
of this, my lord will indicate that. The records pertaining to the SNS. State level
Okay,
scrutiny
okay.
record will contain the district also.
Mhm. Heard Mr. Bhuyan, learned counsel for the petitioner. Mr. Kaushik for the respondent in elementary education department. Mr. Learned counsel for respondent number 7,
567.
567, and Ms. Fukon for respondent number 7. It appears that by the order dated 17/9/2025, the learned standing counsel for the respondent number 1 and 2 was directed to produce the entire record. To produce the entire record, entire file before this court. But the same has not been produced before this court. Accordingly, Mr. Kaushik, learned standing counsel for the respondent in elementary education elementary education department is directed to produce the file containing the recommendation of the district level committee and also the state level committee before this court on next date. List the matter on
In respect of NC Kosumara ME School.
NC Kosumara School,
Kosumara ME School,
ME School.
Borpeta.
Lordship, I filed reply also, note. I filed reply against the affidavit in opposition, filed press 1 or 2. It is on record.
It is on record.
It is already placed on record. SSL list the matter on
15 December.
Obliged, Lordship.
11.
My Your Lordship, matter pertaining to provincialize of my service by law. I am entitled to provincialize under 2011 Act, my lord. But respondent authority arbitrarily provincialize my service under 2017 Act, my lord.
You have filed your reply.
My lord, I have, my lord.
File.
File.
When?
My lord,
26/11.
my lord, there is a similar order, my lord, may dispose of the
I
matter.
think your lordship can dispose of in terms of the division based order, where the division bench has directed to take a decision with regard to fixation of the scale, with respect of the tutor. In Mohorali, that's a.
That decision is part of the record.
Decision to decision.
This one.
The similar order is to be passed.
Okay.
Okay.
Complete.
Next.
Item number 12.
Your Lordship.
In this case, the petitioner before lordship was initially appointed in the year 1996
Hmm.
as stipendary teacher, my lord.
Hmm.
Thereafter, my lord, on completion of the junior basic training,
Hmm.
her service was regularized. Her service was also subsequently confirmed by the authority, my lord, against subsequent vacant post.
Hmm.
But all of a sudden, my lord, since 2006, salaries were not paid. She approached the authorities time and again, but salaries could not be paid. And my lord, finally, by the impugn order at page 40, 31/2021, page 40, my lord, he was adjusted without the benefit of the past service. And that is why, my lord, this order has been put to challenge. Meantime, my lord, she has also retired from service without any retirement benefits. Stand of the respondent is that, my lord, that the petitioner was appointed because the rule without against non-sanctioned post. That was their stand. But the initial appointment order clearly indicates that I was appointed against a retired vacant post. On confirmation, my lord, commission of non-availability of the post does not arise, my lord. My service was confirmed in the year 2006 itself.
Where is the appointment order?
My lord, Lordship will find the appointment order at page 20, my lord.
Yes.
After, my lord, he was paid the regular scale of pay as per approval of the subdivisional level advisory board at page 22, my lord.
So annexure 1 is the appointment order.
Yes, my lord.
Annexure 2 is the regularization order.
My lord. By the annexure 2 order, my lord, I was given the regular scale of pay. And I have completed the junior basic training. Plus, you'll find the certificate at page 24, my lord.
Annexure 3.
Annexure 3, my lord.
Thereafter?
Thereafter, my service was confirmed, my lord. In order to proceed. My lord, you'll find
You have received salary till?
my lord.
You have received salary till?
October 2006, my lord.
2006.
My lord. For
Thereafter, what happened?
Thereafter, my lord, no salaries were stopped. The authority says, my lord, due to non-retention of the post, the salaries could not be paid. But she is working in the same school since her initial appointment till retirement. And finally, my lord, by the impugn order, her service was adjusted against a duly sanctioned post, personal post. Okay. And benefit of the past service was not given. And the salary was also not paid for the period since 2006 to 2021.
So what is the strength of the department?
Department Is that my lord, I was illegally appointed and there was no post. And therefore, my lord, they could not pay, and as in terms of the screening committee report, I was regularized. That is their stand. But Lordship will kindly see the annexure to R2, my lord, in a rejoinder, there is a report by the authority. I have reproduced that, my lord, because my lord, earlier filing the rejoinder, my lord, that annexure was annexed incompletely, my lord. I have filed the affidavit today, but that must have come to the record.
Okay. I think that.
Page number, my lord. 82, my lord. First report. Page 77, Lordship will kindly see.
No, what is this annexer?
Page 77,
No, 82, page 82.
page 82 is the list of genuine teachers, my lord. It is continued from page 77, my lord. Page 77 is the cover note, my lord, wherein, my lord, it was stated that I was regularly, genuinely appointed. Second paragraph, my lord, after verifying the individual records of 17 teachers, it is found that the teachers were genuinely getting salary and benefit up to 2006, but looking at the number of total sanctioned posts, their names were not found provided in an incumbency list of the treasury officer by the circle officer Naranpur inquired about the matter and stated that teachers are genuine and they are to get their salary. And the list I have enclosed at page 80, my lord. That is the list of 17 teachers, my lord.
How do you connect this page number 77 and page number 83?
My lord, in fact, my lord, page 83 was enclosed with the page 77. But my lord, while filing the rejoinder, my lord, I could not.
No, you
did
see,
not
this
annex-
page number 77 is a letter
Yes, my lord. This is the
addressed
enclosure
by
of the
DI of School North Lakhimpur to the Deputy Commissioner Lakhimpur.
my lord.
And this page number 83 was issued by the circle officer.
It was found, my lord, after verification, these officers were, my lord, first. There's a direction from the authority, my lord, to verify by the circular officer, my lord.
Where is that order?
At page 76, you'll also see. Page 76, my lord.
Where is the connection between page number 76, 77, and 83?
Perhaps my lord, this 83 is connected with 76.
Hmm?
Because my lord, 76 refers to the circle officer's report, my lord, regarding 17 teachers, my lord. My plan is directed to produce the two letters, my lord. Perhaps, my lord.
Yes, madam. Whether these two letters are available with the authority?
It must be there in the record, my lord. It must be in their record, my lord.
Yes, who is representing Deputy Commissioner? Is spoken.
Deputy Commissioner is not a party in this case, my lord. The departmental. Even the DIF schools, my lord, also can produce, because this letter was addressed to the
DIF
DIF
school.
schools. Page 76.
DI is a respondent here?
Yes, my lord. Just addressed to the DI, my lord.
Heard Mr. I.S. Soike, learned counsel for the petitioner, and also heard Ms. N. Fokon, learned standing counsel for the respondent in elementary education department. Yupa? Miss, your name, please? Is Sharma? Appearing on behalf of Mr. B. Chakraborty, learned counsel, standing counsel for the respondent number 6, between bracket AZ. During the course of deliberation, Mr. I.S. Soike, learned counsel for the petitioner, has drawn the attention of this court to Annexure R1 at page number 76 and Annexure R2, page number 77 of the rejoinder affidavit, and also page number 83 of the additional affidavit filed by the petitioner. But it appears that Deputy Commissioner is not a party here.
Deputy Commissioner is not a party. But this letter at page 77 has been issued in reference to the 76 letter, my lord. 76 letter, my lord, 19 December 2008, page 76, and my lord, 77, my lord, it is reference social fine, 19 December 2008.
But from a perusal of the page number 83 of the additional affidavit, it becomes difficult to connect the same with the page number 76 and 77 of the rejoinder affidavit filed by the petitioner. Accordingly, Anton learned standing counsel for the respondent in elementary education department is directed to produce the original copy of the Annexure R1 and R2 of additional, no, rejoinder affidavit filed by the petitioner, and also page number 83 of the additional affidavit filed by the petitioner on next date. List the matter on 17 December.
Numbers 13 and 14.
This is also similar case, my lord, but in this case, my lord, petitioner is still working. But we'll find the initial appointment, page 19, my lord. In pursuance to the government letter number so and so dated T2 1993 to discharge without any notice and arising reasons hereof, Sri Binod Kaur, village so and so, district so and so, Lakhimpur is hereby appointed as primary teacher purely and posted at Gosani Pukuri LP Vice, Narakanto Sharma retired. So my appointment was made against a retirement packet post. From the appointment order itself can be said.
Mr. Boda, what is the strength of the department?
Here we file our affidavit, madam, here, petitioner was appointed that there are illegal and irregularities. As part of irregularities, they were accommodated. They were accommodated as, the teacher. Particularly, we have the same, and human dixon, madam. Yes, the page 49 of our affidavit. Contributed as the according to there are categories, there are four categories. There are teacher categories. And this is on page 49. Second, in terms of the honorable final order faculty is equal to the passed in WC 104/2004. The reduction is the measure for illegal regular teachers will put a cabinet in its meeting held on 26/2/2011. Due to examining the nature of appointment status of working status of secondary schools, academic qualification exams. The director of elementary education Assam invite application from these illegal appointed teacher during 1991 to 2001. From the year, my one and to be in the local. In response to the advertisement application, see from such after preliminary examination of applications to receive at the director level. In the evaluation of the 5 screening committees headed by the divisional commissioner. Constant and the regional secretary of the 6 scheduled areas to examine this applications. After details and of the record, also after support shortly hearings of the application, the screen of the submitted report to the government. After examination of the government, facts have been of the large number of cases were appointed on 6 in the very near the pain of this appointment. The substantial number of candidates on the street were appointed to the school, committed on the school. According to the provision laid down Assam Limited, excellency had no power to appoint itself in a provincial school. All the candidates were appointed on the exit school. That is in excess of the existing code. No records regarding appointment. Are available. Most of the illegal level teachers were found in the irregular attendance in the. Most of the teachers did not receive the from the end of joining and some of the up to a certain period.
all salaries were discontinued since 2007. Only the teachers of slips salaries up to February. By the course getting to performance programs. Here, which has illegally appointed money.
Mr. Bora, there is a decision of the division bench of this court. In that division bench decision, it has been directed to pay salary to all the teachers.
Well, here, they were appointed as part of the decision of the cabinet. They were
No.
not salaries, this cabinet. On the basis of the order.
No, the decision of the division bench is prior to the cabinet decision. It was in the year 2015 perhaps. Available that decision?
I'll have to see.
The decision of Justice K. Sridhar Rao and Justice P.K. Soikia.
I will find.
Perhaps in 2015 or 13 like that. I'm not sure the year.
Not by district, related to not by district, my lord.
Maybe, but that decision is referred in most of the cases.
I will find. Matter, my lord, of the 17th itself, my lord. The diameter has been fixed on 17th. Also, you pick it also.
17. Okay. Heard, Mr. I. Soikia, learned counsel for the petitioner, Mr. P.K. Bora, learned standing counsel for the respondent in elementary education department. Heard in part, list the matter on 17 December for further hearing.
Oblige, madam.
Number 15.
But in this case, my lord, and
I'm sorry, my lord, for this structure not fixing the file. Still the recommendation. Photo department search for get the file. If my last grant me for 2 weeks time.
2 weeks.
2 weeks, my lord.
2 weeks. Okay, heard. Mr. Sigdar, learned counsel for the petitioner, Mr. S. Das, learned standing counsel for the respondent in higher education department. And Mr. Abedin for respondent number 7. Mr. Das, learned standing counsel for the higher education department, praised for and granted 2 weeks time to produce the recommendation of the SLC concerning the private respondent. List the matter on
18 December.
18 December.
My lord. Item 16.
Here, your lordship. We have filed our affidavit, your lordship.
When?
Lord, they have filed their affidavit and
11 November.
11 November. And we have also given a reply to that. We have filed on Friday.
9.
Then, Lordship, she says that it's not on record, unfortunately, because
It is not available on the record. You have received the copy?
yes, they have received the copy. Copy to paisa.
So, heard Mr. Amel, learned counsel for the petitioner, Ms. P. Das, learned standing counsel for the respondent in secondary education department. The learned counsel for the petitioner submits that he has filed on a rejoinder affidavit on last Friday. Last Friday. But the same is not placed on record. Accordingly, it is provided that SSL lists the matter on
It'll be tomorrow or day after, Lordship. Some urgency. I will make some effort on my part to get it.
fourth. List the matter on 4th of December by taking the affidavit in reply filed by the petitioner.
Oblige.
Keep your.
Malad, in this case, by respondent number 2, today we have received affidavit, Malad, today.
It filed by respondent number 2, my lord. Today we have received.
You want to
Probably
file-
not in the record also, my lord. So today filed they have.
You want to file a reply?
Yes, and to file a reply, but subject to my lord, short date may be given, my lord. Short date may be fixed, my lord. Within
Short
shortly, I will file my reply, my lord.
Heard
And in the
Mr. Azad,
meantime, I have
Learned
another
Counsel
prayer, my
for
lord.
the Petitioner. Uh, Who is appearing for the elementary? Mr. Sisti, who respondent in elementary education department.
SSA file.
Ms. Borthakur for respondent number 1 and 3. SSA 6.
My lord, 6 not filed. They should file within that. For vacation any date, my lord. Otherwise, their affidavit also will not take on that day.
Okay, the learned counsel for the petitioner submits that he will file a reply to the affidavit in opposition filed by the respondent in elementary education department. Prayer allowed, recessal is the matter on 17. In the
Apply here.
meantime, the respondent number 6 shall also file the affidavit in opposition. List the matter on 7.
Must. Section 18.
Their presence is required, lordship. That's.
The university is the main part.
Pardon?
University is the main party, my lord.
Who is appearing for university?
PJ Shoikia.
PJ?
Sorry, PJ Pukon, sorry. Lordship, on 6 to
Is he
20.
present in the court today?
No, Lord. Kindly see the last order dated 6 to 24. 6 to 24 asks file affidavit. More than near about 2 years, Lordship. 6 to 24.
Okay, let Mr. Pukon come. I will take it up at 2 o'clock. Kobe, inform Mr. Pukon.
Item 20.
May it please your lordship. Lordship, one writ appeal is pending before the division bench. Similar matter.
Division bench.
Yes, lordship.
When that matter is listed?
It's listed on 11/12, next
11.
11/12.
So we will list this matter after 11/12. Heard, Miss?
S. Sharma.
Learned counsel for the petitioner. Mr. U. Sharma for respondent in secondary education department. And district level committee, Mr. Devi. You are Ms. Pukon for respondent number 4 and
2 and 3.
respondent number 4. 2 and 4. Ms. Sharma, learned counsel for the petitioner submits that similar matter is pending before the division bench, being writ appeal number 57 of 2024, and the same is listed on 11/12/2025. And accordingly, taking note of the submission of learned counsel for the petitioner, it is provided that recess and list the matter on
15/12.
Yeah,
19/12.
19/12.
Right.
Bail hearing 21.
May I please, your lordship, matter may be possible for the time being, lordship.
Time being, okay.
number 22 for orders.
Twenty-two.
The last of the I made a submission of the.
22 is the. Content to it. Finance তো তো দুই তিনটা ডেট বলে
21/11 of the SI.
Yes.
In this matter, on 21st of November, the proposal has been sent for SIU approval, the finance department, in respect of the petitions for filling up.
Where is that letter?
It is taking long time, Lordship, observing this matter from a long time. Then submission, Lordship, 3 date after selected by the SLC, 3 date already over.
So now the matter is pending before the finance department. Is Mr. Soliha is available in the court today? Finance department. Yes. I said matter. Mr. Kosik, have you sent it to the
60 day project. I'll send it, Melody. You also can take a photo. That is also there. Well, I have forwarded the copy to Mr. Babu.
Mr. Barbuzari, apprise this code on next date. The status of the letter sent by the secretary to the Government of Assam School Education Department.
Verified, my lord. The proposal appears to have been sent to the finance department seeking approval. Accepting instruction of the spread of this letter. Subsequent kindly accommodate me for 1 week.
1 week.
Because now, my lord, the assembly sessions there, my lord, all the officers are engaged in assembly.
This is the letter.
Perhaps the assembly session is over.
The assembly program, there is a supplementary demand for the both questions are there, the finance department is overburdened. So I cannot.
Okay, 1 week. Yes. Heard Mr. A.U. Ahmed, learned counsel for the petitioner, and Mr. B. Kosik, learned standing counsel for the respondent in School Education Department. Mr. Kosik has produced a letter dated 1/12/2025. It is dated today's letter.
It is a communication, Melody, informed us by the sent on addressing to the standing council member.
When it was sent?
It was sent on 21/11/2025. The paragraph paper.
Okay.
And the reference,
And on the basis of the said letter, Mr. Kosik has submitted that the Department of School Education has already submitted the proposal to the Finance Department. Accordingly, Mr. Borpuzari, Learned Standing Council for the Finance Department is requested to obtain status of the aforementioned letter and to apprise this court on next Monday. Next Monday, Mr. Borpuzari, next Monday?
Next Monday.
Yes. Mr. Kosik shall furnish a copy of the letter to Mr. Borpuzari during the course of the day.
I've given.
Rest is a list on the letter produced before the court today shall be marked as annexure E and B. Take with the record. Okay.
Madam, for admission, item number 42, order, Mr.
Time. Today morning we have filed our additional affidavit, but.
We have received it now, the additional affidavit they have filed today, and our affidavit might not be filing within these days. So might not, we'll fix the matter on the ninth. Ninth of December, the Tuesday.
As agreed by learned advocates of both the parties, recess shall raise the matter on 9th of December 2025. In the meantime, recess shall take the affidavit filed by the petitioner and also shall take the affidavit filed by the state respondent with the record.
Items 43 to 45.
May I please, Roshi? But these matters may be taken in the second half, my lord. We'll take, they have filed their affidavit, my lord. We need not file the reply to that affidavit. So matter will be taken for disposal at second half, my lord.
That rule number 7 has filed the affidavit today.
Today.
It is not against us.
Okay, are you ready to argue the matter? Ready? Okay.
At 2 p.m.
Ready? Second half?
And their faculty have been approved by the inspector of schools. At the rate of minimum scale of pay. Yes. One B, 8 the list of the schools for which they are under prior to 2011. The original act.
Yes.
Just to prove the provincialized and the Constitution of India, my lord, they have got the your lordship will find primary secondary education. The list of subjects avoid them under the Constitution of India. Serial number D, it includes. The stack of the this melody, necessary authority. After the enactment of the 2017 Act by the state of Assam, they has prepared a draft bill at 74 Annex 3. The draft bill made by them. The Dima's house. Facilitate the provincialization of the services of the teachers who are researching in the secondary schools. Other secondary schools in the district of Masa. Whatever thereafter, my lord. Annexure 4, page 81. The Deputy Commissioner Aplong, by letter dated 28 March 2018, has forwarded this bill to the Commissioner Secretary to the Government of Assam, Hills Areas Development.
Page number?
Page number, my lord, 81.
81 is a notification. Annexure 10?
Page number 8. My lord.
No, page number 81 is the Annexure 10. But you have requested to take up the item number 45.
What?
Where's the number? Yes, page number 82, Annexure 4.
Yes. Letter, the bill was forwarded to the government, my lord. Commissioner, Hills Areas Development. After this, my lord, to the file, Annexure 5, page by 53. This bill was communicated by the Commissioner and Secretary Department to the Chairman Committee for preparing roadmap, including new acts and rules pertaining to Education Department. It was forwarded to the Chairperson. And thereafter, my lord, you will find. Committee is constituted. The Government of Assam in Secondary Education Department is pleased for preparing the modalities for implementation of clause 163 of the recent accord. This committee has been constituted thereafter, my lord. The committee convened the meeting, page number 87, Annexure 7, my lord. Resolution. After threadbare discussion, it has been decided as follows. A workshop will be organized in the district of Dimasa for provincialization of schools, public colleges. In the workshop, the details of relaxation to be done in the provisions of the Assam Education Professional Services of Teachers and Reorganization of Act 2017 on each of the section of the Act to facilitate the provincialization of schools, colleges of Dima Hasao district. the additional director education law will prepare a list of schools, colleges to be provincialized as per the recommendation of the workshop as mentioned above, along with their financial implications, and will submit the committee constituted by number of the meeting ended. Thereafter, my lord, the workshop will be the next day. And as per the workshop, my lord, annexer enclosed. So what is the list of schools? The minors. Period. The workshop, my lord, was again forwarded on section 9, page 95. For forwarding of the minutes of workshop cum meeting held on 12/11/2020 regarding provincialization of the services of ad hoc schools and colleges. Forward to the chairperson. And if the 10 members would sign, the letter has been provided issued by the Imamasa Autonomous Council to the Director Secretary Listener Staff. With reference to the subject cited above, I have the honor to submit herewith the recommendation of the Scrutiny Committee of 12 members of ad hoc high schools, non-provincial schools under the Assam Education Provincialization of Services of Teachers and for the Reorganization of Education Act 2017 as amended in 2018. Fine, Act number 99. And these are the list of the system here and data method provided, and the timeline of the members of the district level scrutiny committee at last page at 1. Annexer 10 is 11D, page number 102B. One letter has been issued by the DSC Assam to the Principal Secretary SC Hills Autonomous Council. With reference to reading 102B. With reference to subject cited above, I have the honor to submit state that a proposal for provision of 14 numbers of schools, non-provincial schools was received from your good office by the letter mentioned under reference. In this context, I would like to mention that out of 14 numbers of schools, report of district scrutiny committee will receive in respect of only 2 schools, Lodi High School, as per clause 10 of the Assam Education Provisional Services of Teachers and Reorganization of Education Act 2017 as amended. The recommendation from the district scrutiny committee is required for placing the matter before the state level scrutiny committee for verification of the recommendation. As per the recommendation of the district scrutiny committee, have not received any in respect of 12 numbers of schools. The matter should not be placed before the state level committee. You are therefore requested kindly to submit reports of the district scrutiny committee in respect of 12 numbers of schools at the earliest for taking further necessary action in this regard. Actually, my lord, the previous annexer was the report of the 12 numbers of schools. You will find the previous annexer 11A is the report of in respect of the recommendation of in respect of the 12 numbers of schools. Submitted already. What happened, my lord? After that, without taking into consideration, is exercise of one. It is the power of the my lord Education Act of 2017. There is Act of 2017, my lord. One notification has been issued by the secretary. Without taking into all this development, all this aspect, and they are my lord the bill also, which is provided and submitted, and they have also acted up. They have issued this notification, whereby my lord they have got my lord paragraph 2 onwards, 104, page number 104. Whereas the welfare educational institutions covered under 6 scheduled areas in each districts cannot be the welfare educational institutions in the meaning of the subsection 2 Z-D of section 2 of the said act unless such institutions are brought under the purview of the act by a separate notification to be published in the official gazette. And whereas neither any proposal for inclusion of these institutions established under 6 scheduled areas in hill districts are forthcoming, nor any separate legislation have been enacted by the concerned authority to provide provincialization benefits to the employees of those institutions. And whereas the welfare educational institutions of 6 scheduled areas in hill districts, including all other districts in the state of Assam, submitted their proposed applications in proper format as prescribed by the government, along with the other documents for consideration of provincialization of services of employees of their institutions. And whereas on the recommendation of the district scrutiny committee, followed by the approval of the state level committee considered under section 13 of the said act, the government in the school education department have provincialized the services of employees of the welfare education institutions falling under 6 scheduled areas in hill districts. And whereas the government, the school education department is satisfied that the circumstances exist which render it necessary for it to bring the welfare education institutions of 6 scheduled areas in hill districts under purview of the Assam Education Administration of Services of Teachers and Reorganization of Education Institution Act 2017 for provincialization of services of their employees. Now, therefore, in exercise of powers conferred under section Z-D of section 2 of the Assam Education Provincialization of Services of Teachers and Reorganization Act 17, the governor of Assam is pleased to bring the welfare education institution of 6 scheduled areas in hill districts under the purview of Assam Education Provincialization of Services of Teachers and Reorganization Act 2017. This is impugned because, my lord, they have filed coming to the conclusion have already ignored the admitted position that they have not received the proposal, that there was no proposal from the demand. So this entirely baseless final statements in the recorded because the proposals have already been written in the district level scrutiny committee has already submitted the recommendations and the relaxation with regard to their legislation that also been written by them. Everything is clear. Instead of that, my lord, ignoring this entire aspects, admitted position record, they have, my lord, issued this impugn notification in order to have the teachers of the teachers in the schools of the Dima Assam district, which they cannot, my lord, because the Constitution of India has provided them special legislative power, and under that special legislative power, my lord, they have made the rules in consonance with the 2017 Act. And therefore, my lord, this impugn notification is not at all, my lord, sustainable. This is the one submission of the case, my lord. And apart from that, my lord, you will find financial implication. As per their earlier communication, financial implication, my lord, this letter is issued by the director of the election party, page 106. In consonance with this notification, they have issued this cancellation, my lord. With reference to the subject cited above, I have the honor to inform you that the committee to examine the difficulties arise in provincialization of schools in 6 scheduled areas of the state. Accordingly, a meeting was held on under the chairman of in the conference hall of SEBA office to discuss the as per discussion made in the meeting, the additional director of education Haflong was requested to organize a workshop in the district of Dima Assam for provincialization of schools and prepare a list of schools to be provincialized along with their financial implications. Subsequently, the Principal Secretary SDS Autonomous Council Haflong submitted the minutes of the workshop regarding provincialization of services of ad hoc schools under Dima Assam district of Yento. In the context, it is stated that a proposal for commission of service in respect of 14 high schools was submitted by the principal secretary LCS Autonomous Council Haflong by letter number 27 under relaxation criteria under Dima Hasa district of Yelko. The principal secretary LCS Autonomous Council Haflong submitted the ESC report in respect of 14 high schools by letter number 27. Further, UDICE report for the year 2014-15 and result of examination for the year 14 and 2022 have been collected from Mission Director Samogra Shiksha Abhiyan, Samogra Shiksha and Secretary Seba. As per the report of Seba, it is found that the schools do not fulfill the eligibility criteria for publication under Publication Act 2017. This is for your information and area. Because they are not at par with the general area. All tax special provisions have been adopted. And the matter as far that they have submitted the proposal for their enactment, legislation instrument has been forwarded. But without taking into that to a logical conclusion, my lord, they have stated that they are at par with the general areas schools and on the basis of tax notification, they have, my lord, stated that these schools cannot be provincial. Another aspect of the case. Then my lord, you'll be fine. They are those teachers, those petitioners, my lord, they are not like the bencher school teachers of the general areas. In general areas, my lord, the bencher school teachers do not get any remuneration from the government. They are earlier they were given the financial assistance, but it is stopped thereafter. But in case of Dima Hasa, special provisions are there. They are treated as ad hoc employees. And my lord, for that financial grants are given every year. Every month, my lord. This is the, my lord, financial budget. Annexure 48, page number 107. Which refers to subject cited and in pursuant to the members of the executive committee meeting.
Okay, Mr. Pokesh, so not required to read out this.
Yes, sir.
For the name.
Their present status is that, my lord, they are getting the salaries as per the minimum scale of pay, which was enumerated in the 2010 ROP. Thereafter, it is revised in the year 2017, my lord, through ROP 2007, FPI Commission, my lord, which is ROP 2017. It has, but they are continuing with the minimum scale of pay as per the ROP 2006, which is already over.
No, now what is your pair in this petition?
Yeah.
You are challenging the annexure 12 only.
Annexure 12, as well as, my lord, prayer for enhancement of their salary at the minimum scale, my lord, as per the present ROP. The law will find, I am just giving the, my lord, their structure. Page number 117 is the ROP of, my lord, 2010.
Okay. Yes, what is yours then?
They are challenging is state government's notification, so state government will be okay.
Oh.
And blockchain about the ROP also state government the plan and
So they're now they're getting salaries as per recommendation of the ROP of the year 2010.
Instead of 2017.
Yeah, so why their salary has not been reviewed as per recommendation of the pay commission in the year 2017?
The principal secretary's office or the CFO's office, and then we get the lordship. So we have the inspector of schools.
Okay, Mr. Kosek, you are appearing for the
Here, my lord, the petitioner basically will not. So he's seeing that they have been receiving salary as per to the ROP 2010. Although they have been utilized under the Act of 2017. And under the Act of 2017, although this salary. What I could understand from the repetition of paragraph 7.
No, their services have not been provincialized. They are working as ad hoc employee.
Yes.
This notification, my lord, which has been issued.
Annexure 12.
Annexure 12.
Yes.
In this situation. But this is a notification issued under the Act of 2017, my lord. JLP, my lord, you can see. Take this book, my lord, for a moment.
But all the facts mentioned in this notification are incorrect.
My lord, what?
The facts mentioned in the notification are incorrect.
Incorrect, as in, my lord?
Because he has pointed out the earlier annexures of the writ petition.
Well, this notification is for the purpose of bringing the schools under the 62 areas under the ambit of the 2017. Now, my lord, petitioner, my lord, has how the petitioner is agreed by this notification, my lord, I don't find anything in the from the petition. Lord, Lordship will kindly see the who jet the first one definition of the C107 of the. Page 107 of this. Venture, it is the definition. Venture educational institution means and includes Venture Degree College, Venture Higher Secondary School, Venture Junior College, Venture High School, Venture High Madrasa, Venture ME School, Venture ME Madrasa, Venture Upper Primary School and Venture Lower Primary School situated within the state of Assam, excluding the areas covered under 6th schedule of the Constitution of India, unless a separate notification for inclusion of the venture education institution in such area is issued and published by the government in the official gazette. Now, this notification, my lord, was brought for bringing those schools under the ambit of 2017 for granting the benefit of provincialization. Now, how this, my lord, the petitioner says that they have not been provincialized under the 2017 Act. So this notification will not affect them. This is a notification only to bring the schools under the, so that the benefit of provincialization under this act can be extended to the schools of the venture schools of 60. And the under this act, my lord, the salary which is being paid to a tutor is section 8, my lord. Section 8, page 117, subclause 3. Page 117. Section 8 provides the terms and conditions of service. Subclause 3 is in relation to tutors, For tutors whose services are provincialized as tutors under this act, their scope of work and other conditions of service shall be notified by the concerned administrative department separately. The emoluments for the tutors shall be paid at the rate as specified in schedule.
No, that is only when their services are provincialized.
Provincialized.
But their services are not provincialized. They are working as ad hoc.
That's why I'm not understanding, Miller, how this notification is affecting them. Because this is notification only for the purpose of bringing the venture education institutions under the ambit of 2017. How the petitioner is aggrieved by this?
Mr. Pukesto, explain it now.
My lord, as per JD, the impugn notification is issued. It ought to have been issued my lord, the act provided, the bill submitted by the NC Hills to the government, my lord, that has to be notified in exercise of the power given under JD. Instead of notifying that, my lord, bill, they have, my lord, stated that this it has been brought under this act. special provision is where special provision for Dima Hasao, meaning thereby, my lord, they have been empowered under the Constitution of India, my lord. They will prepare their own bill, my lord, and it will be own act, my lord. There will be that has to be, my lord. Government has to notify, my lord. Instead of doing that under in exercise of power given under ZD in the act, they have issued, my lord, ignoring this entire aspect. That's why it is hampering us, my lord, because we cannot compete with the general areas. We are in the hill areas. We cannot compete with the general areas. Therefore, the government cannot make us at par with the general areas. Constitution has provided us the power to frame our own laws, and we have framed it. Instead of acting upon that, my lord, they have issued the impure notification whereby they have ignored the existence of the submission of the proposals, the submission of the bills and everything. Straightway they have brought us in the main act. That cannot be, my lord. That is the reason we could not be provincialized.
He is resorting to page 75, that is a bill, my lord.
That is the bill. This bill has to be acted upon, my lord, to make it an act.
He's asking for amendment from this court to, my lord, to pass an act.
No, I am not asking for this, honorable court to. I am asking, my lord, this impugn notification which is issued. This is not as per the procedure. This is not as per the law. That I am submitting, my lord. Follow-up actions, consequent action will follow automatically. They cannot take away the constitutional right of the NCLs, my lord.
Such case, my lord, there has to be a challenge to ZD, my lord. Because this is a notification issued under the power that is conferred by a statute under Article 309. Its notification has a technical force, my lord.
No, but
That cannot
special
talk-
provisions are made in respect of the 6 schedule areas.
Yes.
Like, if that be the sufficient law, and this is a notification issued by the government, my lord, under section 2ZD, my lord. That 2ZD is a provision, my lord, which has been under a rule of framed under Article 309. And, my lord, what his case is, my lord? His case is that there is a bill which is yet to be an act, and therefore this notification is banned.
This special provision has been incorporated in the act itself in order to, my lord.
Notification is not covering, my lord, that whether this petitioner should be paid minimum pay scale under 2010 or 2017. This notification only brings the venture educational institutions under the 62 areas within the ambit of 2007, so that the benefit of provincialization can be given to those venture educational institutions also.
No, that's all right, but while the 6 schedule provision is there, why the same has not been followed? Instead of this notification is impugn notification is issued? No, they have already passed one bill.
Prepared a bill.
As per 6 schedule to the Constitution of India.
Yes.
So why the state has not acted upon the same?
That's followed instruction I'll have to take, my lord. Why the bill has not been acted upon?
Instead of a separate notification has been issued.
This separate notification has nothing to do with this one. This separate notification does not even affect the petitioners.
So this separate notification, they have incorporated the entire.
If your lordship will kindly allow me to read, my lord, paragraph 7 and 8, my lord, the pleadings in the repetition. So this is what I gather from the repetition. Neither here nor there, my lord.
Paragraph number?
Paragraph 7, my lord, page 41. It's a long paragraph. The petitioner begs to state that all of a sudden the respondent number issued a notification dated, so my lord will kindly allow me to read from paragraph 6. As per the decision dated 9/11/2020 adopted by the duly constituted committee, the authorities of the Dima Hasao district have organized a workshop on so and examine and scrutinize the eligibility of the high school to be provincialized, and also adopted a resolution by incorporating and the relaxed criteria of eligibility. The committee has prepared and recommended a list of 12 numbers of high school out of 25 numbers of schools. The proposal of 12 numbers of school after the scrutiny has been forwarded by the Principal Secretary NC Hills Autonomous Council by letter dated 6/6/2022. The Principal Secretary NC Hills by its forwarding letter dated 26/11/2022 has also submitted the details of the minute of the workshop and proposal for provincialization of the schools along with the recommendation to the chairman of the committee constituted by the government for provincialization of the schools and colleges in respect of 6 schedule area. It is needless to mention here that out of 25 numbers of school, the Dima Hasao authority has earlier scrutinized and recommended 2 numbers of school, namely so and so, forwarded a proposal by 15/2/2019, which has been reflected by letter dated 29/4/2022 issued by the TSC Assam. It is therefore construed that the 40 numbers of high school have found eligible and qualified by the district level supervisor. Now, my lord, can see parasol. The petitioners stated that all of a sudden the respondent number issued a notification dated 11/1/2023 when the government has suppressed the materials facts on record and proposals of the draft bill of 2018 framed by the NC Hills Autonomous Council in exercise of the constitutional legislative power vested under the provisions of Clause D of Para 3(1) of the 6th Schedule of the Constitution of India, and also suppressed the recommendation in respect of the high school made by the district level scrutiny committee, which has been forwarded by letter dated 6/6/2022 as per resolution dated 9/11/2022 adopted by the committee constituted by the government by notification dated 23/9/2020. The Constitution of India is the supreme authority and prime source of law in India, and therefore the mandates of the Constitution is binding upon the public authority. The NC Hills Autonomous Council in exercise of the constitutional legislative power has framed the bill, thereby adopting, my lord, kindly note this, framed the bill and thereby adopting some relaxation and special consideration for determination of the eligibility criteria for the purpose of provincialization of the schools and colleges which have been established and running in the financial aid from the non-planned head of the government of Assam with minimum scale of pay, Schedule 2 ROP 2010. Section 2ZD of the Provincialization Act of 2017 empowers the government to issue necessary notification in order to include the areas covered under 6th Schedule of the Constitution. But such inclusion has to be in conformity and spirit of the mandate of the Constitution. In the instant case, the authorities of the ST Hills Autonomous Council in exercise of the legislative power has framed the bill 2018 which is duly acknowledged and has been acted upon by the government to some extent with regard to the incorporation of the relaxation criteria. The response number 1 in total suppression of the above constitutional, legislative and administrative action taken by the NC Hills Autonomous Council has issued the impugn notification dated 11/1/2023. This is one of the ground of challenge. Where the state respond in exercise of the absolute arbitrary and administrative power in violation of the mandate of the Constitution of India has issued the impugn notification dated so whereby Dima Hasao dispute has been brought under the purview of the Assam Education Provincialization of Service of Teachers and Regulation Educational Institution Act 2017. Without incorporating the provisions and clauses of relaxation proposed in the Bill 2018 submitted by the authority of NC Hills Autonomous Council. Director of Secondary Education thereafter issued follow-up impugn communication dated so addressing to the respondent where the Director of Secondary Education Assam has rejected the proposal for provincialization of the 14 numbers of schools in total submitted by NC Hills Autonomous Council by letter dated 6/6/2022 and 15/2019 in exercise of our administrative and arbitrary administrative power. It is the duty of the Director of Secondary to apprise the government with regard to the proposal received before issuing the impugn rejection order and not to have submitted a proposal to the government for modification and cancellation of the impugn notification. The perusal of the impugn notification testifies that fact that the Director of Secondary, in spite of receipt of the proposal submitted 6/6/2020 from NC Autonomous Council, has not forwarded the same and has been kept it pending till issuance of the impugn notification. For not apprising the government by Director of Secondary Education about the receipt of the proposal for NC Autonomous Council, the respondent number 1 has taken the ground that no proposal has been submitted by the NC Autonomous Council. Now, my lord, this notification under 2ZD is not for the purpose of only Dima Hasao. it is a general notification under the statute, so that the statute is made applicable to the other 6 schedule areas, because in the other 6 schedule areas also, the benefit of provincialization has been granted to the 6 schedule areas, to all those venture education institutions who otherwise were not within the ambit of the 2017 Act, unless the notification is issued. So, my lord, the petitioner's case is that there is a has placed in 2017-18. Now, if your lordship will kindly see the bill method.
No, we are not deciding the merit of the bill. We are concerned with why the
Because
same has
ground
not
is,
been
my lord,
considered.
The ground of challenging the notification is
Hmm.
not by virtue of the legislative competence.
Hmm.
Notification is not being challenged that the authority, the commissioner and secretary do not have the competence to issue this notification.
Hmm.
Or this notification is in violation of the statutory rules.
Hmm.
Now, the only ground of challenging the notification is that their recommendation has been cancelled and the director has not apprised the commissioner and secretary regarding the pendency of this recommendation,
Hmm.
under which was issued prior to the notification came into.
Hmm.
That is the only ground of challenge, my lord.
Hmm.
Now, if your lordship will kindly see the bill, my lord, what is this bill about, this 7 years?
Hmm. Yes.
This bill has been framed, my lord. The preamble of the bill, my lord, where it is expected to provincialize the ad hoc institution concerned services of employees of the district of Dima Assam in respect of to secondary school. Now, this is the legislation which is proposed, my lord, it is yet to be an act. Now, if the petitioners say that, no, we don't come under the 2017 Act, we don't claim any benefit under the 2017 Act, then this notification is not applicable to them.
Hmm.
Like, am I clear on this? Because and this Act of 2017, my lord, is a act framed under Article 309 of the Constitution.
No, it has specifically mentioned in the notification.
Hello?
To bring the venture educational institution of 6 schedule area in the hill district under the purview of the Assam Education, Provincialization of Service and Research, and Reorganization of Educational Institution Act 2017, or provincialization of service of their employee.
And 2 JT, my lord, empowers the governor to issue a notification for bringing the institution under the Act of 2007.
Hmm.
Under such power, my lord, this notification is being issued.
Hmm. No, whether this ZD empowers you to issue such a notification.
Yes, sir.
Hmm. Here it is mentioned excluding the area covered under the 6th schedule.
Unless a separate notification for inclusion of the venture educational institution in such area is issued and published by the government in the official gazette.
Hmm.
Unless it is a notification is issued, otherwise the 6 schedule areas till then was excluded within the ambit of.
Hmm.
And this notification brings the the venture education institution within the ambit of 2017 for giving them the benefit of provincialization.
And applying that notification, the director cancelled all the proposals, my lord. Had it been in favor of in the beneficial purpose, my lord, the director of secondary education ought to have been processed that same proposals, my lord. Instead of processing my lord, they have cancelled because it has made at par with the general area criteria, and that doesn't fulfill by the Dima Assaw.
Yes,
That is the thing outcome.
second best person in notification.
Nine.
And the complete notification is also not.
It was available, this much is available in the website, my lord. Only.
Complete notification is also not there.
Completely, this is A2A. Physical digital sign হয় ভাই to first page to ওলাইছে second page দিয়া নাই আর ডাইরেক্টর একটু দি পেলে হেৰি কৰিছে ফাইল
So, better, Mr. Kaushik, you produce the entire notification before this court and you come with the special instruction as to why the bill forwarded by the autonomous council has not been placed before the secretary. And why their salaries are not paid in terms of the
ROP
payroll of 2017. Mr. Sharma, you obtain instruction in that regard? We will list the matter after vacation.
Yes, your lordship.
Heard Mr. B. Purkestal, learned counsel for the petitioner. Mr. Kaushik, learned standing counsel for the respondent in Elementary Education Department, Assam. And Mr. Sharma for respondent number. Respondent number 7. Ms. Borua for respondent number 4. 8. Okay. Okay. Heard in part, list the matter on 19 January. In the meantime, Mr. Kaushik, learned standing counsel for the respondent in Elementary Education Department shall produce the complete notification dated 11/1/2025 and also annexure number 12. Annexure number 12 and also Mr. Sharma, learned standing counsel for the respondent number 7 shall obtain instruction as to why the benefit of payroll of 2017 has not been extended to the petitioners. List accordingly.
Obliged.
Number 28 promotion.
May I please, your lordship, kindly pass over the matter for the time being? For the time. He is in another court. He is in
Another court.
Yes.
He's in another court. He's on lake in another court.
Okay, after some time.
Turning as 18 for admission.
Lordship. Mr. Pokon was there, Lordship, sometimes therefore he discussed with me, he sought another date, Lord. Short date, please. As informed me.
Another date.
Okay.
Okay. Heard Mr. Sarkar, learned counsel for the petitioner. Mr. S.C. Das, learned standing counsel for the respondent in higher education department. And none appears for the.
He was there.
He was there, okay. And Mr. P.J. Fukun, learned standing counsel for the respondent, Guwahati University.
Mr. Sarkar has pointed out that the respondent Guwahati University has not yet filed the affidavit in opposition. Accordingly, it is provided that Mr. P.J. Phukon, learned standing counsel for the Guwahati University, shall file his affidavit in opposition by okay.
Lordship, shorted may begin within December, Lordship.
December. Okay. When? Within Friday. Okay.
16 December. It would, can it be taken up on next week, Lord? The affidavit is almost ready, but the controller of examination of the clinic he has been recently, Lord, re-inducted.
Okay. COVID next week.
12.
12.
Most of them.
21, very better. May I please?
Yes.
I'm on behalf of Dr. Kiran Shiva.
Pardon?
Appearing on behalf of Dr. P. Agarwal, responding to the leave lordship.
Okay.
Should we kindly join the matter for the case?
After?
Kindly any short date will be given only. This is bail matter only.
After?
15th of December.
15 will be too long.
On 8th.
8.
8th of
Heard Mr. Barbuya, learned counsel for the petition. Mr. K.K. Das, learned additional PP for the respondent number 1 and Miss
S. Nath.
S.
Nath.
Not learned counsel, appearing on behalf of Dr. P. Agarwal, learned amicus query for the respondent number 2. Respondent number 2. Vishwanath submits that Dr. Agarwal is on leave and she prays for listing the matter on 8th of December. Pair allowed, recess list the matter on 8th of December.
Diploma. Number 46 for admission.
May please your lordship. In this case, my lord, form 29, the food is now supplying, my lord. And that apart, respondent number 4 filed an affidavit in opposition, my lord. I need some times to file my rejoinder, my lord. Food has already been provided, my lord, from 29th of night.
Okay. Heard, Mr.
May I understand?
Learned counsel for the petitioner. Ms. D. Bowman, learned additional senior government advocate for the deputy commissioner. Siram. Oh no, Baksa. Deputy Commissioner Baksa, and Ms. Bora for the respondent to BTC. And for tribal affairs, your name? Your name? Appearing on behalf of Mr. Ardhar, learned standing counsel for the tribal affairs. One. Ms. K. Phukon, learned standing or learned junior government advocate for the respondent number 1, 2, 3, and 4. 3 and 4. During the course of hearing, Ms. D.D. Burman, learned additional senior government advocate, has produced one report received from the deputy district magistrate Baksa, dated 30/11/2025, and on the basis of the said letters, he submits that food and water to the students of EMRS Dolbari Baksa has been provided pursuant to order of this court passed in the present writ petition. Present writ petition. The learned counsel for the petitioner submits that he has received a copy of affidavit in opposition filed by the respondent number, tribal affairs respondent number respondent number 4, and he prays for granting him some time to file his reply to the said affidavit in opposition. Where alone, let's list the matter after 1 week.
Sometime it is a bulky affidavit, my lord. 4 weeks, man. It's a bulky reply, man.
So my lord, we have filed the affidavit.
It's a bulky affidavit in opposition. I need some time to answer all the, my lord.
After 1 week. After 1 week.
2 weeks, my lord, kind of.
Let's list the matter on
16th.
sorted.
My lord, 16, I have some problem, my lord. After 16, my lord.
No, before 16.
Before 16.
11.
11th.
Item 23 for orders.
These are short matter also.
Badla Rangapani High School lordship. Post lordship. Provincialized in the year 2030. My name was on 14/6/2013 for provincialized in one of the post of China. But because of the long pending litigation between the petitioner and the respondent number 6, my the claim of the senior was declared was this claim is on the basis of senior. And on the other hand, lordship, my learned friends, this claim is also basis of subject community. He claimed that he has a he is royal, he along with me should have to be provincial.
Okay, if we are not ready to
allow with this. 2013 onwards, sir, they are dragging this matter like this, lord. Lordship, I have given the judgment along with that.
So let us fix it on a hearing day. We'll finally dispose of the matter, both the matter. Okay. Heard Mr. Eskedas, learned counsel for the applicant in the IA number 1274 of 2025 and respondent number in WPC. Respondent number 6 in WPC number 4387 of 2023. Mr. Alifo. Opposite party number 1 in IA and a rate petitioner in WPC number 4387 of 2023. Mr. Daspo, respondent number 5. Respondent number 5, Mr. Usoma for respondent number 1, 2, and 3. Okay, in the rate petition. As agreed by learned advocates of both the parties, recess shall list the matter on Thursday, 9th. On that day, an endeavor will be made to finally hear and dispose of both this petition.
Number 24.
Oblique. My lord, matter may be taken after some time. Mr. Bhuya is on leg. Mr. Bhuya is on leg.
By the Mahima Court line. You have to wait for the steps on the number of 1311.
So service not completed in respect of respondent number 5. I didn't. Heard, mister?
To myself as an account. That is pending matter. I may be, I may kindly leave it of this case.
That application is on the record?
Well, it was filed before the registry, madam. It is.
Steps away from steps. What was that? Assistant or the service.
So the principal has already been retired. So you have to implement the present incumbent. Heard, mister? Learned counsel appearing on behalf of Mr. A.R. Bhuya, learned counsel for the petitioner, Mr.
J. Soikia, my lord.
J. A. Soikia, learned counsel for the respondent number 3. Governing body. Mr. Soikia submits that he has already filed one application for withdrawing his Ukalatnama. But the said application is not placed on record. When did you file?
Month of August, my lord.
The month of August.
That is another file. On 9/7 it is filed. On 9/7, July.
Okay. Okay, it is, yes, it is on the record. He has already filed an application on 9/7/2025 for withdrawing his Ukalatnama in respect of respondent number 3. You have already issued notice to them? Notice to him? And he has also issued one notice on 24/6/2025. Annexer X of your petition. Accordingly, taking note of the submission of learned counsel for the respondent number 3, the application dated 9/7/2025 stands allowed. The petitioner shall take a step to bring on record the present incumbent as
respondent number 3. I am respondent number 3 in this petition. Office note dated 3/11/2024 indicates that notice upon respondent number 4 and 5 are yet to be completed. Accordingly, learned counsel for the petitioner is directed to take fresh step upon respondent number 4 and 5 by registered post with AD and also by usual process within a week from today. Additionally, dusty service is also permitted, and after effecting service upon the respondent number 4 and 5 by dusty mode, the petitioner shall file one affidavit to that effect before this court. Place the matter after 2 weeks.
Item 25.
This contempt application is related to my salary, my lord. The earlier incumbent, my lord, has already retired, my lord. Now holding the post.
Heard Mr. R. Sharma, learned counsel for the petitioner. Mr. Sharma submits that the earlier incumbents have already retired from service, and as such, he submits that he may be granted some time to bring on record the new incumbents. And press for listing the matter after 2 weeks. In the month of January. Pair allowed recess shall list the matter in the first week of January.
Item 26.
Honorable Court's order from page 14 onwards. There was direction to create supernumerary post and to make payment. So what they have done, they have accommodated lordship, the regular salary has not been given to us. Although in this case, your lordship, they have utilized our services, budget allocation has been given, my lord. Supernumerary post, the same post, their lordship. But your lordship, not reinstated, we have never been thrown out. Accommodated us. The fact is that lordship in the cycles line orders are issued by the respondent authorities. And lordship, it was issued to us the blanket orders of appointment have been given. We are not given the chance to look at what are the contents of the appointment order. To sign and undertaking given by them. It has because NPS, that's first two batches. Lordship,
No, now you tell me
My lord?
whether the direction given by this court in the writ petition has been complied with by the contempt or not.
They have sanctioned the section order by allotting budget allocation in favor of us by giving retention. But we are receiving salary after we were accommodated from 2022, if I'm not wrong.
When the budget allocation was made,
And actually,
is 33.
yes. 3 onwards. To submit. Along with the proposal of area strategy for the period effect from March 2012. With working certificate issued by the concerned headmaster of the respective schools, with duly countersigned by the concerned block elementary education officer. The next page, my lord. With reference to the subjects that is above, I have to forward here read copy of the speaking order issued by the government by order under reference and request. You to submit a proposal for creation of 10 numbers of supernumerary posts and area salary for the period with effect of March 2012 with the working by the concerned headmaster of the respective schools with countersigned by the concerned PU and deputy inspector of schools. On payment of salary, payment to the petitioners the week from so and so. Then budget allocation, my lord. The numbers are given from
Hmm.
01. And our names are mentioned from 1 to 10. What happens to the money which is in our favor, Your Lordship? This also that has been allocated in our name. And yet the account has been mentioned as 36. As if for payment of area salary to us.
No, in the meantime, this allocation might have elapsed. No, Mr. Sisti.
Yes.
In the contempt petition, we will never adjudicate such kind of dispute.
Yeah.
We will only see how the order of the court has been complied with.
The accommodation.
No, Mr. Sisti.
Yes.
You see, what was the direction of this court?
Directions, but because they have accepted and they have said that they will not claim the area salary. No, sir, in a similar case, Lord, and a coordinator base has passed this order in this contempt.
No, Mr. Sisti. You see, whether you have complied with the direction issued in the writ petition or not.
They have complied, they have, first of all, they have gone to a scrutiny process. They have subjected themselves.
No. They have subjected or not subjected. That is not the question before this court.
Themselves, they have said they will not claim the area salary.
No.
They have joined as a new accommodator. As a accommodator, as a teacher.
No. You tell me whether you have complied with the direction of this court in its letter and spirit.
Lordship, we have complied because they have accepted their present posting and they have forgone their area salary. They said it is agreed by the director, Lordship. Agreed by the director, there are. And in similar case, this coordinate of the
No, that may be in the writ petition, separate writ petition, but.
When the petitioner is agreed to have declared the notice, in a contemplation number 571 to this 706 of the similar notice, this honorable court, the coordinate bench has stated that X settlement has been arrived with the party as per the submission of the council town stands through. Exactly on the similar ground, they have accepted the figure. This is also contempt case of 2017. This is also contempt case of 2018.
No, that cannot be.
But they have, yes.
No, they have filed their affidavit. What is in your affidavit?
On 3/9/2025. If we have agreed to the proposal, whatever they have done, place the content application.
If they have any, it revolves against this accommodation. They have not waited for it. Now they are joining, they are getting salary. They have given a.
You won. Also, indications been made in a that they accepted their appointment on purpose. They have accepted to sign undertakings, but they have not forfeited their earlier claim of payment of salary. They are not aware of our indicative which has been taken after passing of the order in this Wednesday. By this honorable court. There is no illegality committed by the petitioner and the petitions are appointed after following due process of law and under the relevant Assam Elementary Education Service. The answering deponent states that the respondent authorities after utilizing the services of the petitioner cannot deny the payment of salary to them. The answering father states that prior to their joining on 21, they have communicated to the Director of Elementary Education Assam Kahilipara about the order so very clearly ordered to the respondent authorities to release their area salary by granting annual retention of superintendent and release the current salary to the petitioner within a period of 2 months. Accordingly, the respondent authorities have released their salary with effect of 1/11/2020. But question of retrospective effect of the legitimate due salary from 1/3/2020
28. We deliberately ignored. It's part of the criteria in that. In the above mentioned communication, they have stated that they are willing to join the new assignment, but if they are compared to undertaking, NPS agreements, any other agreement, etc., concern authority, then such undertaking NPS agreement, any other agreement cannot proceed down or reports order it is so and so. This further figures in that requirement of one under the aid of economics of work also created by the district elementary education officer Sonari for requirement of area salary in the event of the method denial of area salary then is very low.
I don't have the copy of this.
Already scan copy given to them on the last occasion.
I have been asked by the honorable court for FPR notice. You can see the exact.
Okay, furnish a copy to him.
He didn't have any copy.
No, Mr. Sisti, you see, merely because some of the coordinate bench of this court have closed some of the contempt petition, this court is not bound by those orders. We have to see whether the order of this court has been complied with or not. No, Mr. Sisti, you see, the order was passed before constitution of the cabinet. Cabinet.
No, that was in 2012. It was issued in the this appeal order was issued in the year of six. It was filed in 2018.
Whether you place the decision of the cabinet before the honorable court, when the honorable court passed the order in our favor.
Dr. Test Steering Committee, it was constituted in the order of this honorable court in the published in the newspaper. All of the petition they had subjected them to that screening process. They have found irregular. That's why they recommended that picture.
No, here we cannot decide that issue. Oh, here we will only see how the order of this court is complied with. Maybe that in view of the affidavit,
Yes,
in
sir.
reply,
Yes,
that argument cannot be accepted. Heard Ms. B. Bhuya, learned senior counsel, assisted by Ms.
B. Bora,
learned counsel for the petitioner, and Mr. SMT Sisti, learned counsel for the contempt.
8
Respondent number 8. Mr. Sisti submits that he has not received a copy of reply affidavit filed by the petitioner. Accordingly, it is provided that Ms. Bhuya shall furnish a copy of the affidavit of the petitioner to Mr. Sisti during the course of the day so that Mr. Sisti can obtain instruction and apprise this court on next Monday.
$27.
May I please, Your Worship? 12/8/2025. That day, Lordship.
On 29, cancel and again they have returned back the file to the verification. So that instruction I will do it again. And he has just told me that they have sent the file back to the inspection of again.
Okay. So, yes. Heard Mr. P.K. Das, learned counsel for the petitioner. Ms. Upadhyay for
number 1.
respondent number 1. Mr. Sisti for respondent number
2 to 6.
And Mr. Deori for 7. Mr. Sisti, learned counsel for the respondent number so and so submits that as per his information, the proposal submitted to the Directorate of Pension has again been returned to the department,
To the inspector of school, Kasar.
or to the inspector of school Kasar. And in respect of returning of the file, the required information is not available with him, and he prays for listing the matter after a week so that he can obtain necessary instruction in this regard. They are allowed rest to list the matter on Monday. Next Monday.
Item 28.
Kindly pay.
Department with their, the last of the director. Yes. From the judicial department. On 1811, finally forwarded to the education. 1811. Okay. Mr. Kosing, you received the.
Yes, but can it be after 6, because the secretary is not there. For updated instruction.
Okay. Heard Mr. Khondokar, learned counsel for the petitioner. Ms. Didi Burman, learned additional senior government advocate. Appraises court that the file has already been returned to the Department of School Education by the Judicial Department. Mr. Kosik submits that the secretary is out of station and as such he prays for listing the matter on 12. So as to enable him to obtain updated instruction. They are allowed. SSL is the matter on 12.
Item 29.
In this case, Lordship, kindly peruse the order dated 18/9/2021.
So, and I'd like to mention that here a review petition has been filed, so I'm finding number
Lordship.
9/6/2025 Lordship.
9/6.
5 public 2025. It is the filing number.
Earlier occasion, so kindly peruse the order dated 18/9/2025. Lordship. This scheduled dialogue Lordship, and without getting any proof, Lordship, that after filing my purchase petition, they came with a review petition, Lordship, which is only a filing number, just to delay the matter, Lordship. Then the coordinate bench of this honorable court. They are not giving any benefit of that, Lordship. The honorable court has directed, Lordship, to give a personal benefit of that, Lordship. That Lordship, they are not filing an affidavit. And the coordinate bench of this in another matter, Lordship, 50,000 was fined on that, Lordship, in the review petition. Last occasion, Lordship, they have, this honorable court also that instruct Lordship 18/9/25. Lordship page 5, each session for the error cannot be found for the and the error has to be palpable one and who no new facts are discovered after filing the contempt petition by the contemplated regarding the this case was last occasion the this honorable court.
No, Mr. Majumdar, you see, this order was passed in a review petition. This present is not a review petition, this is a contempt case.
But contempt, Lordship, they are not filing any affidavit, Lordship. At least I should know the fate of that, Lordship. The honorable court order, Lordship. 18/9/25. Kindly, the last occasion order, Lordship. Last order. 18/9/25. If they will not file any, Lordship.
Lordship, I will ask Mr. Andrew Kapner if you want to file it. And may kindly pass
Heard
me around.
Mr. K. Majumdar, learned counsel for the petitioner. Mr. Sistel, learned counsel appearing on behalf of Mr. N.J. Khatunier, learned counsel for the contemptor, submits that one review petition has been filed, being filing number 96650 of 2025, and he prays for listing the matter on Friday. So that Mr. Khatunier
Mr. Khatonia may appear and argue the matter. They are allowed to socialize the matter on Friday.
Apply. Number 92. 92. It is actually covered by your another judgment. I will place my lord, recently your lordship's part. Page number 92. I take your lordship. The second paragraph, paragraph 13. While disposing this petition, my lord, it was not pointed out regard to the statutory power of the academic councils of the universities before this honorable court. And that resulted to the, my lord, direction. Accordingly, this writ petition stands disposed of by directing the respective academic councils of the universities, that is Guwahati University, Dibrugarh University, Tezpur University, and Assam University, to take the aforesaid decision as regards the eligibility of MSc in biotechnology to participate in any recruitment for the post of assistant professor in botany and zoology within a period of 6 weeks from the date of receipt of the certified copy of this order. This is the direction, my lord. And my lord, basing on this, my lord, this Guwahati University has issued a page number 86. Is the one notification has been issued by the academic register, Guwahati University. It is notified for information of all concerned that as per academic
Page
council.
number, page number.
Page number 86, my lord.
Yes.
Notified for information of all concerned that as per the academic council Guwahati University resolution number such and such dated such and such, the MSc degree in subjects like biotechnology, microbiology, molecular biology, etc. cannot be considered as concerned subjects for the post of assistant professor in botany and zoology in the degree colleges affiliated to Guwahati University. This is the order notification has been issued, my lord. I take your lordship to the statutory power of the Guwahati University Academic Council, my lord. Page number 120.
This is a review petition.
Yes, lordship.
Review
This
of the order dated.
Order, my lord, page number 92.
22nd of February 2021.
Yes, lordship. This
What
statutory
is to be reviewed?
in this this operative direction, my lord, this only this part, my lord, page number 92, paragraph 13.
What is to be incorporated here?
My lord, this honorable court given a direction to the universities concerned to take a call with regard to the eligibility equivalency of the biotechnology master degree, my lord, MSc, with regard to the zoology and botany. This direction was given to the concerned in all the universities, but the Guwahati University has taken a decision that it is not at par with. But this is not within their jurisdiction because the statutory provisions given at page number 121. Page number 100.
What is the ground for review of this order?
Because this statutory provisions could not be placed before this honorable court on that at the time of passing the judgment. This was not placed before this honorable court. Because third party review, I was not the party in the writ petition. This is a third party review. This honorable court granted me leave. Thereafter, I filed this review petition.
And why the concerned document could not be placed before the court?
This was because it was the third party, because the other writ petitioners and the respondents were there. But this statutory provisions with regard to the power and functions of the academic councils of the concerned.
By which order leave was granted to you?
My lord, it was page 92.
No. By which order leave was granted to you?
Connected miscase is there. My lord, connected miscase is there. Then that miscase
But whether a third party can maintain a review petition?
Because we are aggrieved by the consequential order passed by this Guwahati University following the judgment of this honorable court, my lord. That is why we have the aggrieved, and we could not be presented before this honorable court during the proceedings of the earlier writ petition. That is the reason, my lord, we have been granted the leave to present this review petition. And the simple thing is that, my lord, the statutory provision.
Thing is not simple as submitted by you.
Lordship?
Yes, whether a review petition by a third party is maintainable. You have agreed before the court in advance that you have no objection. But the question is whether a third party can maintain a review petition.
Actually, Malad, he has preferred one appeal, my lord. Yeah. Okay. He preferred an appeal, my lord, to file an appeal against that order, my lord. Then, my lord, court has directed actually to prefer a review. And we said that we have no objection if that application is allowed.
Review petition is when maintainable. And who can file a review petition? The parties
Parties.
who were already in the writ petition? But admittedly, the present review petitioner is not a party to that proceeding.
Yes. Therefore, I preferred an application for granting me permission to move this review.
No, that permission is granted, that is a different matter, but the question is, we have to see whether this petition is maintainable or not by a third party. Had it been filed by one of the
Writ petitioners.
writ petitioners or the respondents, then we could
Case will
have,
be different.
yes.
I will also
So
examine.
come prepared.
Yes.
Heard Mr. Purkaiso, learned counsel for the petitioner, Mr. S.C. Das, learned standing counsel for the respondent in higher education department, and Miss learned counsel appearing on behalf of Mr. A. Samoa, learned standing counsel for the respondent UGC, Mr. P.J. Pokon for Guwahati University. M. Roy for the respondent number 11. List the matter on 16 December. For hearing on the point of maintainability of the review petition by a third party.
God bless.
31.
May it please your lordship, my lord.
Yes.
Here, by this honorable court by order dated 29/11, it was almost a consent order, directed the respondents give opportunity for promotion by holding TPC within 3 months from the date of order. But that was not done. Now both the contemners in this petition have filed their respective affidavits. And from the affidavit, it appears that they are guilty of contempt because within that time bound period, they didn't do anything. And after expiry of that period, started writing letters to the university and all, just to show that it is beyond their power, give the effect on their own.
My lord, we have already taken steps, my lord. And
For
complying with the order, my lord, we have written to the university for the recommendation of the experts from the university, this is nominee. And that after filing our affidavit, certain subsequent developments have taken place, my lord. So we need to file an additional affidavit, my lord, to bring on record. So maybe we will get the PTC constituted very soon, so that the petitioner's case may be considered. It is under active consideration, my lord, of the college. So I need some time to file the additional affidavit to bring on record the additional subsequent developments, my lord.
no, we are not concerned with your subsequent development. You comply with the direction issued by this court.
Steps to comply with the order, my lord.
That is my
Okay,
worst,
after some days.
that is my worst apprehension, my lord. By delaying the matter, they want to punish me, but they are bent upon destroying my career as a professor, lordship. That's my worst apprehension. Again,
No, no, if that was your submission in the writ petition, then we could have dealt with the matter in the different manner.
Actually, it was there, my lord, but being compared, I just agreed to a consent order. I thought that if they consent to it, then they will move. But even thereafter, they remained as it is.
So within 2 weeks, you complete the entire process.
My lord, we are in the process, my lord, so that's why.
No, no, you are in the process, you cannot continue the matter for another 2-3 years.
No, that will not continue, my lord, because once the nominee from the Guwahati University is received, my lord, then we can constitute the DPC, my lord. We cannot constitute the DPC on our own, because the DPC has to be represented by one subject expert and by the nominee of the VC.
No, you see, this order was passed on 29/11/2024.
My lord,
And it was a consent order.
my lord. And 3 months
Then
time.
what you have did in the 1
We have
year?
taken the affidavit, my lord. We have taken sufficient steps, my lord. And now the latest development is that might be we'll be holding the DPC very shortly, my lord.
In the affidavit, you have to explain each and every delay.
My lord. Because all the letters, lordship, they have annexed in the affidavit, they were written before the time period. Much time not allowed, my lord. Much after that, they started writing. And now they want to lean upon that. Even the petitioner was asked to deposit the documents, my lord, he did not deposit the documents within the specified time, my lord. So then that we have denied. In our reply, we have denied, lordship. We have explained how things progress.
Heard Mr. C. Chaudhary, learned senior counsel assisted by Mr.
It's Sweden.
Hayes,
It's Sweden.
learned counsel for the petitioner, and Mr.
N. Borwa.
N. Borwa, learned counsel for the contender. Mr. Borwa, learned counsel for the contender, submits that they are in the process of complying with the order of this court. And he will file one affidavit bringing on record the step the contemners have taken. There is allowed recessal list the matter on 16th? 16th. 16th of December. Okay. 16th of December.
Items 22 and 23.
Your lordship, my lord, your lordship may peruse the last order dated 6/11/25. The operative portion, my lord. 1 week time was allowed, and if they do not file the affidavit in opposition, then it will proceed without the affidavit being filed by them.
We have also received the instruction, but it is not proper, my lord. So some clarification is required, my lord. So sometime maybe granted.
No, in writ petition or the contempt petition?
Writ petition.
Writ petition.
My lord, 2013 onwards, there is a judicial order. Then the contempt was there. They came before the contempt. They said, no, we are complying with the order. Then the contempt was closed. Then they passed a different administrative order against which we have come over here. I am 58, I have crossed. Though there is judicial order of provincialization, I will not be provincialized before I retire. If this is the situation, my lord, 13 onwards, I am fighting onwards. My lord. And there is a judicial order from this court. I have annexed everything, and they are not filing it.
Yes, file ukalatnama today, let him obtain instruction.
Not in the contempt, my lord, I am in the writ petition. Writ petition, my lord, your lordship peruse the last order. In the writ petition, my lord, last order
No,
was.
one by one. First, let me deal with the contempt petition.
My lord.
So in contempt petition, you have filed your ukalatnama. Heard Mr. Chaudhary, learned counsel for the petitioner, Mr. 64 respondent contender number 1, and Mr. Sharma for 2. Mr. 60 submits that he has filed ukalatnama
for the respondent number 1 today. Then accordingly, it is provided that receive shall list the matter after 1 week so as to obtain instruction by Mr. Sisti, Learned Counsel for the contender number 1. And what is your instruction?
In the contempt matter.
Today?
Yes, yes, ma'am.
Okay, today. Mr. Yusona. For is is there any connection between the WBC and the contempt matter?
My lord, the only thing is this, my lord, because of there was a violation of the earlier order, that is why. It may not be tagged up together also. There's no.
Okay, in contempt petition, we will fix a short date.
Short date, ma'am.
Okay, on next Wednesday, 10th. In WBC, now you tell me.
My lord, your lordship may just peruse page 70. 70, there was a judicial order. They went for an appeal also. Appeal was dismissed. Page 70, there was a judicial order. That because I was the senior most, I was provincialized under the 2011 Act. Then one of the 2011 Act, because the private respondent who challenged my provincialization came to the court, there was a stay order. And ultimately that act was declared ultra virus. But when I approached the court, said because of a judicial order, though he was provincialized, he was not given the effect. So he should be given a deemed provincialization. That is at page 70, judicial order from this court. The relevant portion is at page 72, para 5.
No, now what is your pair in this writ petition?
Writ petition, my lord, after this judicial order, my lord, there comes another administrative order. Now, there was a contempt petition filed. When in the contempt petition, my lord, they approached and said at page 79 that we are doing the complying with the order. At page 79, your lordship will find that the aforesaid order reveals that the compliance of the aforesaid direction of the court, the service of the petitioner against the third arts graduate such and such school as per Assam Venture Act has been moved by appropriate department for concurrence. It has also been clarified that the said order would not be treated as a precedent in other cases. So the contempt was closed. Now they come up with an other direction of this court with my lord. In the meantime, they went for an appeal also. Appeal was dismissed. Now the administrative order comes, the impugn order comes. 91, the impugn order, present impugn order.
91.
93 is the relevant portion. That the government will not give you the concurrence.
So you have not filed your affidavit?
No.
Some clarification is required regarding the instruction matter. So some time may be granted so that we can follow affidavit in opposition matter. And now move on system matter of 25 matter.
Maybe it does not mean that you will not file your affidavit in opposition. So we'll grant you 1 week time, you file your
10
affidavit.
days, my lord. 10 days.
No.
And this will be the last chance, my lord, because last occasion also.
Third, Mr. Roy Chaudhary, Learned Counsel for the petitioner. And Mr. Yu Sharma, Learned Standing Counsel for the respondent in Secondary Education Department. Mr. Sharma submits that though he has received some instruction, but the same are not complete. and he pressed for granting him 10 days time. However, 1 week time is granted. This is a list the matter on next Wednesday, 10th of December. It is being clarified that no further chance will be granted to Mr. Sharma to file his affidavit in opposition. Please accordingly.
Item 34.
Item 34, the grievance for the petitioner that her salary has been stopped. That has been also been released, Lordship, my instruction.
Salary released.
There one another prayer, Your Lordship, in this, there's a violation of the status quo order 8125 in IN, Your Lordship, that they have not given any reply, Your Lordship. In the last occasion, they said they will file a reply.
My instruction, verbal instruction that she is holding the post, Lordship. There is no violation. I don't know how he is.
No, the Lordship, what has happened is originally a transfer order was passed, which we challenged the writ petition, Lordship. And there was a from the honorable court saying that no coercive actions will be taken. Despite the order, again a so-called notice was served upon the petitioner, saying that she has not gone to the transferred post and disciplinary action may be taken against her. So we filed a reply against the saying that this is already a sub judice matter, and it is also direct violation of the court's status quo order. After that, again the petitioner's salary was blocked. So after that, we filed the contempt petition. And after filing the contempt petition, the salary was released, Your Lordship. That we have already submitted before the Honorable Court on last occasion. That part we have agreed, Your Lordship. But there was also one contention why this disciplinary proceedings was filed against her during the pendency writ petition. Until now, that has not been dropped. So
There can be a subject of the writ petition that is pending. Writ petition has already been pending, Lordship. This is a contempt petition regarding non-payment of salary. That we have already released. The writ petition is still pending, Lordship. He can raise all these objections, all these grievances in the writ petition, Lordship.
in this case, it may be tagged with the writ petition, and you can like both the case can be like
No, yeah, what was the direction of the court?
in the writ petition, Lordship.
No, this contempt case.
Contempt case, there's been no reply or yet, Your Lordship.
No.
Direction to court. He has given so much of annexes, so it is very complicated, Lordship. This.
No, Your Lordship,
No,
it is very,
where is the order of this court in the writ petition?
Lordship may kindly come to page number 87, Your Lordship.
87.
87, no coercive steps to be taken against the petitioner.
So this is a order dated 8/1/25. Page number 89 is operative for Your Lordship. So this was a no coercive action to be taken order, and this was this order was also renewed in the next days and is valid till date. Despite this order, the contemptor issued a show cause notice, and show cause notice is in page number 90, Your Lordship.
No, this contempt case is initiated for violation of which order?
Two orders basically. One is this, the stay order dated 8/1/25.
And where is the main order?
Main order is page number 122, Your Lordship. Copy of order dated 21/8/25.
122.
122, Your Lordship.
Always against the interim order, Lordship.
So after Your Lordship may come to page number 124, para second, Your Lordship. The learned counsel submits that despite an order passed by this court in WBC number 2825 dated 8/1/25, wherein this court had ordered that till the next returnable date, no coercive step be taken as a petitioner, which has been extended time to time, the respondents have passed the impugn order dated 11/8/25, wherein disciplinary proceedings were initiated against the petitioner, and the second charge made against her is for non-compliance with the transfer order. The learned counsel submits that this is in violation of the order of this court dated 8/1/25, and hence the instant IA. Issue notice to respondents, and the last para, sir, having heard the submission made by the learned counsel or petitioner, this court finds it appropriate the status quo be maintained till the next date of listing. List the matter after 4 weeks for the respondent to file the written objection, if any, positively or negatively. In this, no reply was filed. However, her salary was blocked.
So being compelled, we filed this contempt petition, lordship. After that, yes, the salary was released, but this particular this so-called notice has not been dropped till date, and is still a violation of that order, and that's why we are pressing on the contempt petition, lordship.
No, you have challenged this order in another writ petition.
Yes. Yes, in IA we have filed, your lordship. We have filed the IA in that writ petition, saying that despite the order dated 8/1/25, they have issued a dismissal proceeding, your lordship.
One way they have filed the IA and other way they have filed the contempt motion, so under the same.
No, there are two different instances, lordship. One was against the issuance of the discipline proceeding. The second is for the blockage of the salary, your lordship.
So you drop the contempt, no, drop the so cause notice, disciplinary proceeding.
Specific instruction I will take, yes, I will ask them to drop it, yes.
You comply with the order.
Yes, yes.
While a stay order is operating, how can you issue so cause notice to her?
I think that instruction, I think by the time it has been dropped, and that instruction I don't have, even it is not written in the instruction, I have seen it, lordship.
Yes,
But
here
salary has
only
been-
release of salary.
Salary is there,
Uh.
only dismissed, lordship, yes.
Heard, Mr.
J. Das, your lordship.
J. Das, learned counsel for the petitioner, Mr. S.M.T. Sisti, learned counsel for the contempt. During the course of hearing, Mr. Sisti has produced one letter of the director dated 29/10/2025. On the basis of the said letter, he submits that salary of the petitioner has already been released. The learned counsel for the petitioner also submits that the petitioner has received the salary, but the so cause notice by which disciplinary proceeding was initiated against the petitioner has not yet been dropped. Mr. Sisti, learned counsel for the contempt, submits that he will be granted some time to obtain necessary instruction in this regard. We are allowed, recess is the matter on Monday, next Monday.
Highly obliged, lordship.
Item 25.
May I please, Your Lordship, this IA is preferred against the criminal appeal, Lordship. Lordship, what happened, Lordship? There was an order passed by 27/9/23 by the special judge Karbi Anglong, Lordship, where I was convicted. And Lordship will find the order in page number 8, Lordship. And dear Lordship, my conviction was 7 years and 6 months, Lordship, but essential part is on the page number 9, Lordship. The vehicle, my vehicle was seized, Lordship. And Lordship was pleased to allow this appeal, Lordship. That judgment is on page number, Lordship, 10. The operative part in the page number 31, Lordship. Lordship, may I read, Lordship? Lordship, in the result, I find sufficient merit in the appeal, and accordingly the same stands allowed. The impugned judgment of the order conviction of the learned trial court stands set aside. The appellant shall be released from the jail hazard forthwith if not warranted any other case, Lordship. Lordship, but Lordship, the says vehicle, Lordship, there was no direction for that, Lordship, and my vehicle is still in there.
No, what was the direction of the trial court?
Lordship,
Whether the trial court has issued any direction
Lordship, the vehicle.
while convicting you?
Yes, Lordship. The direction was on page number 9, Lordship. The vehicle bearing number MN01AG5829 says during the inquiry shall be a government property henceforth. Competent authority is directed to initiate appropriate steps for confiscation of the said vehicle. It is in the page number 9, Lordship. Lordship.
So if the appropriate authority has already initiated the confiscation proceeding, the court has no jurisdiction to consider the same.
Lordship, we have filed this IA for that Lordship, to allow us the direction to or the release of the vehicle, Lordship, as per section.
No, that is not automatic. Merely because you have been acquitted, you will not entitled to the vehicle.
Lordship, we have filed this IA as per Lordship section 454, Lordship. As per Lordship 452, Lordship. So we are here, Lordship, for section 454, where subsection such appeal, the appellate court may direct the order to be stayed pending disposal of the appeal, or may modify, alter, or annul the order and make any further orders that may be just, Lordship. So this court has its jurisdiction to.
Whatever I want to state here, Lordship. Firstly, in this case, document another case in 416, wildlife is there, Lordship. Firstly, I want to reflect on that, Lordship. It would be better because they want to moreover, in this, it is true, Lordship, in the trial court order, it is, it will be property of the government, Lordship. In the order, in Lordship's order, Lordship, in 51 days, nothing is stated that it should not be released or like that, Lordship. It should be released or it is not dealt with, Lordship. So, the learned trial court, in my opinion, Lordship, humble opinion, that the trial court has the authority to do that, Lordship.
But they are saying, Lordship, as there is no direction from this court, Lordship, they were not releasing the vehicle, Lordship. What's your humble
No,
prayer, Lordship?
whether person to the acquittal order passed by this court, any confiscation proceeding in respect of the vehicle is started by the forest department or not? No, I am asking him. Whether they have started the confiscation proceeding or not. You obtain instructions.
I will be also there, Lordship. Lordship, in page number 10, Lordship. Not 10, Lordship.
Notice that. Isn't not in excess.
Mr. Das, when you have received the copy,
In page number 11, Lordship.
when you have received the copy of this petition, when? When this matter was assigned to you? Why you have not gone through the record? Why the instructions are not available with you? As to whether the confiscation proceeding pursuant to the conviction order passed by the learned trial court has started or not?
I apologize for that, Lordship.
No, you obtain instructions.
Look, I will take off the instruction.
Heard, Mr.
A Mena, Lordship.
Learned counsel for the applicant, then Mr. Das, KK Das, learned additional PP for the state respondent. This interlocutory application is prepared by the applicant for issuing direction to release the vehicle bearing registration number MN01AZ 5829 in terms of the judgment and order dated 13/5/2024, passed in criminal appeal number 416 of 2023. Having heard the submission of learned counsel for both the parties, it is provided that Mr. Das shall obtain necessary instruction as to whether any confiscation proceeding was initiated by the state respondent pursuant to the conviction order passed by the learned trial court in Special Wildlife case number 11 of 2022. Place the matter on after 1 week.
On 9th.
9th.
Much obliged.
So as to enable Mr. Das to obtain necessary instruction.
By 38.
So I gone through this instruction, Lordship. I said, according to them, Lordship, this DLED diploma is valid if the person concerned is in service on or before 10th of August 2017. Although I am working in a private school, my appointment was of 10th of March 2017. So prior to 10th of August 2017. Now, only difficulty is that, Lordship, for that particular year 2017, my name is not captured under the DIAS code, EU-DIAS code for 2017. Lordship, since I was appointed in the year March 2017, and the capturing data of the teaching staff is the authority is the DO and block level education officer as well as the SSA. Our process is that the head of the institution should apply before the BO, DO and the SSA. Now thereafter, they are also automatically updated the instruction. It is not my duty to upload or capture my name in the DIAS data for 2017. Now, if we go by I am aggrieved by this notice, Lordship may kindly come to page 40, annexure 12, prior to the instruction, Lordship. I was aggrieved by this notice of 19th of November 2015. By this notification says that the candidates, yes, although it is modified, the content is same, that candidates have to submit EU-DIAS on or before 10th of August 2017. Now here it is a case, Lordship, since I don't have the DIAS code for 10th of August 2017, so I could not submit this EU-DIAS in terms of this notice. And one of the contention is that although the advertisement of January 2025, suddenly on 19th of 11, after 10 months, Lordship, they have issued this notice. They are outlining also given that last date is 1st of today. Today is the last date for submission or uploading these documents for EU-DIAS. But from 2018 onwards, I am having the EU-DIAS code. There is no dispute. And so far, the application of the EU-DIAS in the state of Assam,
what is your pair in this petition?
To set aside this notice of 19th of 11, 2025. Because they suddenly, in the midway of the game, Lordship, they have changed the rule because the advertisement as well as the extended date, there is no such stipulation. Now it is only on 19th of November, they are saying that the candidates have to upload or submit EU-DIAS. Now earlier, Lordship, there was no date mentioned. Now while my learned friend was directed to obtain instruction, now they have modified this notice by this document. Lordship, kindly have the instruction branch, Lordship. There is also notice. Now, hereby, Lordship, they have, Lordship, incorporated now the date, specifically the date, 10th of August 2017.
10/8/2017. And this is all because of the direction of the Honorable Supreme Court.
Yes, sir.
And lastly, though we have issued the advisory in the month of January 2025, the Honorable Supreme Court has held that this 18-month period will be eligible to participate in a selection process. Then again, the Honorable Supreme Court lawsuit in a order issued on April 2004, April 4, 2025 lawsuit has directed that there should be a proper verification for those who are in service. So that direction of the Supreme Court came in a midway. So accordingly, we have issued a notification that you should, for being an employer, it is a discretion of the employer. So you file this evidence.
Well, in a similar line of lawsuit earlier, it's a base of nearly 179 people have opposed an honorable court in earlier round of litigation lawsuits. This honorable court has rejected their claim. Lawsuit may kindly peruse this order will clear everything. Paragraph 32 lawsuit, Supreme Court, honorable Supreme Court order has been deflected. Why this very process just came in?
Extra copy আছে I have not gone to this order.
The order, if you see the reported order and appeal has been filed, no stay has.
Even
been
other-
division bench.
There is also
And it
lordship.
was dismissed with a cost of rupees 10,000 for challenging this notification. This is in terms of earlier round of litigation.
No, although
Honorable Supreme Court in the month of April 2025 has said that the employer must verify whether their persons were actually in service or not
We
prior
are in
to
service.
and 8/2017.
Yes, we are in
And it is a
service.
description of the lawsuit employer to verify on what ground. So we say that we submit evidence or as on 10/8/2017 or prior to that. That the petitioner failed. And today is the last day lawsuit. We have extended it till today.
Your Lordship, it is a case of the petitioner that I am in service on 10th of March 2017. Yes, according to the Honorable High Court's order and as well as the Supreme Court's order, Lordship, I am very much in service, March 2017. But difficulty arises, Lordship, that for 2017, my name is not captured and for the year 2017, the UDIS code. But this say that the candidates who have applied, my application is also accepted. But because of this certain notification, Lordship, I could not upload my document. Because suddenly this says that you have to submit the UDIS for the year 2017, 10th of August 2017. But so far the Supreme Court's order, or Honorable High Court's order, Lordship, I am very much in service. 10th of March, if you Lordship kindly come to the Annexure 2, Annexure 3.
Because Honorable Supreme Court in order that in that Kosikas order has stated that the employer should verify.
Yes. So
But
that is,
verification, we have said that being it is a discretion of the employer that we submit the evidence to prove that we are in service. So he's failed to prove that evidence.
Lordship, and I kindly see the instruction, Lordship, kindly come to
The discretion of the
clause
employer.
3, clause 3.
It is Honorable Court.
Now it is their duty to verify the document. I am on this. You verify my documents, take a decision. That's all. Lordship, kindly see the instruction my learned friend produced, Lordship, just now. The clause 3, the first, second, third, fourth paragraph, because a large number, Lordship got it. Because a large number of candidates who were not in service before the cutoff date, that is 10th of August 2017, that have nonetheless claim eligibility under this relaxation category. Verification becomes indispensable to avail legality, merit, and fairness. The only reliable way to confirm such a status is through verifiable records such as appointment, joining, school management committee, attendance register, salary records, UDIS. Now, my contention is that because of the direction of the High Court as well as the Supreme Court, it is the duty of the authority to verify my documents. So let my documents be verified and take a decision, Lordship. And that is why on the first day, the application is kept in abeyance in the interim order.
Today.
So
And we
Lordship,
have extended the-
so Lordship, within a very short period of time, let them have a decision or verify the documents. If I am eligible, then accordingly they will accept my application. If otherwise not eligible, then automatically they will reject my application. Lordship.
No, apart from this UDIS,
Lordship.
there is some other documents also.
All are fulfilled, Lordship. I am having all the documents.
So far as this appointment is concerned, in the notice, we have given only UDIS. Because in earlier round, all the documents were the 6 documents, they have to given all the 6, not one. They have to produce all the 6 documents. Not one document will not do all the 6. Now here, in this recruitment lawsuit, we have given all the, you produce the UDIS only. UDIS is the most authentic lawsuit data, so to prove that a person is working.
No, you say you have mentioned the 5 documents here,
Yeah.
appointment and joining
The
document.
instruction given to me, Lord.
Yes, this
On
is,
its notice, we have given them the, we produce only UDIS.
So you
No,
verify.
why you have not given the option
Lordship,
in
is-
respect of other
Lordship is,
documents?
Lordship, is the discussion of the
No,
employer.
no, no, no.
Lordship, that has been rejected. In earlier round of notification, all these documents were there, they have challenged it. It was rejected by the honorable court, by the coordinate bench, Lordship.
Lordship,
Similar round of.
Lordship, I am selling with their decision. You verify my document, have a decision.
In earlier round.
Until then, my application should be kept in abeyance. I am not against the apex court decision as because I am in service because I was appointed in March 2017. The requirement is 10th
No,
of
why your name has not been captured in
because
the
it is the
index?
head of the institution because I am not aware because the duty to capture the name it is the head of the institution. Whether my name is forwarded or not that I am not aware, Lordship. But from I have annexed the document from 2018 itself and annex 11 series.
No,
My
do
name
you
is
have any document that your name has been forwarded by the head of the institution?
that document right now I don't have, Lordship. But if annexer, Lordship, I have annex document from annexer 11 series from 2018-19 onwards. My name is there. Lordship, kindly see table. 32 annexer 11 series. The name of our school is Lahorighat New. I am working in a private school. Now this notice says the candidates who applied or working in a school or obtain the diploma from the NEOS, they have to submit the UDIS. That was Lordship by the.
They have to be in service
Yes.
prior to one.
Because the but in the advertisement there is no such clause. We are agreed by this because suddenly all of a sudden you incorporated you upload the UDIS for 2017.
That is
Had that clause inserted in the January 2025 advertisement, so we could not apply. Now we have applied. Our application is accepted, and we are having also the DIAS data, but for that particular period of 2017, and probably it is not because I was appointed in the month of March 2017. Now immediately whether the head of the institution supply or forwarded the application to the authority or not, I am not aware. That is why, let's say, I directly, when I came to know before issuance of this notice, let's say, may kindly have the representation, page 31. When we came to know, Lordship, that UDIS is required, Lordship, kindly come to page 31, annex 10. Before issuance of the earlier notice, may I read, Lordship? Prior to enlist my name, the highest authority is the Director of Samagra Shiksha Abhijan. Prior to enlist my name in UDIS of 2017-18 of Lahore Sancho. With due respect and humble submission, I beg to state that I had been working as an assistant teacher in a private school, namely so-and-so. This number is the UDIS number 1800 since 11/3/2017 under Lahorighat Education Block in the district of Morigaon. Though I had submitted my all documents, yes, your Lordship very much inquired whether I have applied or not. Though I had submitted my all documents, but due to departmental unawareness, my name was not enlisted in the teacher's profile UDIS 2016. This is not required. This and 2017 and 18. It is enlisted in UDIS 2018-19, then 21 to 22 in the said school. That's as I have completed my DLED NEOS as in service employed the said school, but my name is not available in UDIS of 2017-18. I'm skipping because this is not relevant for me. 2017-18, which is required as an assistant teacher in a government to serve in a government school. Therefore, you are requested kindly to take necessary steps from your end to enlist my name in UDIS so-and-so, for which act of your kindly. This was, I applied on 4th of November 2025. The first notice came on 19th of November. And the last notice is come out 27. So, Lordship, my application before the authority, so let the authority have a decision. Because otherwise I am eligible. I am in service prior to that cut of that also. So till then, till the decision is taken, my application should be kept in abeyance. That is your last order, interim order is there.
That is till today, Lordship.
Yes, that may be extended within 1 week or within 2 days or 3 days. Let them verify my documents, take a decision.
Otherwise, in a similar case, the Lordship is quoted by an already dismissed.
Yes,
If you have gone to appeal, there is no stay. But just if lordship allow them to continue to verify lordship, whether it will become a contradictory lordship.
They will also deem.
No, but where is the bar in verifying her documents? You verify it. If she is not eligible, reject it.
Yeah. That is why I'm
Where
saying
is the bar?
I'm not.
There is no bar otherwise.
Then
Only no stay or lordship.
No, till the decision is taken, my application will be kept in a base.
Recruitment process will suffer lordship.
No, I'm not staying this order. Lordship may dispose of this matter. We didn't know what.
Otherwise, this
take.
update was held in terms of the direction of the Honorable Supreme Court. And then Honorable Supreme Court in the month of April, this advertisement was issued in the month of January. Then in the midway, the Honorable Supreme Court direction came that you should verify those in-service teachers. And for verification, it is the discretion of the employer lordship to what document we will verify. So we have given in earlier round of litigation, we have given 6 documents. Those were challenged. Those were dismissed by this Honorable Court. And in the appeal, no stay is given. Now this is the second round of litigation. Now we have come down to only the dice, you give dice. Because that is the only lordship reliable source, is an electronic source lordship where we can find that that person is genuinely working.
no, that's all right. You verify the documents.
Yes.
Verify the documents.
Yes.
If it is not there, you reject it.
Yes. Yeah, that observation with this lordship mechanism. Yes.
No, as per the instruction as well as the Apex Court decision, you verify my document. I am not against the Apex Court decision as well as the High Court, although I have not seen this order. Why I am harping? Because my appointment is prior to 10th of August 2017. So I am very much in. The only difficulty is that the authority has not uploaded my name. That is why I am before them on 4th of November. This notice came out on only 19th of November. So till this is within a
School is a private school lordship. It is not whether it is private school.
private school.
No, it's not come under our jurisdiction. And BDAS is normally held by the SSA in the Nepal lordship.
So 1A you says that those candidates who completed the DLED program from NEOS or 18 months, they have to in service on 10th of August 2007.
It is a Supreme Court direction.
Farid, or side any reason is given that candidates should working in a private school or a government school.
There is no.
That is why the earlier advertisement, there is no such clause. That is my case. While the January 2025 advertisement came up, all the criteria is fulfilled by this petitioner. But only because of the 19th of November, when this notice was issued, that candidate have to submit the UDIS for the 2017. They have agreed by this.
Because the Honorable Supreme Court direction in the month of April.
Yes,
2025.
that also I am fulfilling because
Then
my,
you have to verify.
because I don't know also whether those candidates were having appointed or in service or I
Because
have
of
not seen this order. But so far my case is concerned, I am in service on 10th of March
In
2017.
private school, lot of documents are manufactured. That is why Honorable Supreme Court said that you verify. And for verification, and then if they are in service prior to 10/8/2017, then you allow them.
Still I am having that you verify my document. Within a week, take decision whether I am eligible or not.
Give me 1 week.
Yes.
To verify.
The lordship may dispose of matter within a week, they will take a decision. Till then, my application should not be cancelled. If otherwise I'm eligible, then I have to, they have to consider my candidature.
Should not be cancelled if that order is given, and that will give a handle to lordship.
No, no.
If they agree, they can do lordship, otherwise lordship.
That,
That means that.
that decision you have to communicate to me because
Okay,
after,
that will be communicated lordship.
even other also the Department of School Education, the lordship may kindly come to page 8, sir 8, when this UDIS came into force in Assam. For the first time, the Department of School Education and Literacy, page 8, annexure 8, I have specifically stated. The petitioner begs to state, also got it. Page 8, and paragraph 8, that the petitioner begs to state that the Unified District Information System for Education Plus is an educational management information system under the Department of School Education and Literacy, Ministry of Education, under the Government of India. In short, DOSEL. DOSEL have developed the Unified District Information System for Education Plus UDIS from the reference year 2018 and 19. But they are taken up the date of 2017. So the docile has lordship taken the reference of 2018 and 19, and from 2018 and 19, I am having continuously I am having this UDAS number. My name is captured under UDAS from the year 2018 lordship till date.
No, if it is not there in the year 2016 and 17, then what to do?
I am not because in 16 I was not in service. I am in
Then
service.
17, 18?
17, 18. 17,
Yes,
18.
your name is not there.
Not there because it is because of the lordship in my application I have stated it
Then
is the
if
left
is-
of the
no,
authority.
Mr. Deka, you say, if it is not there, they will verify the document, they will not found it.
They have not verified because this application in this representation.
No, in the event of verifying those documents, they will not get it.
They will not get it.
Then they will reject your petition.
Lordship.
Then what purpose will be served? Hmm? If your name is not captured in the years 17 and 18,
so lordship, because if
and if that is the only criteria,
but I
then
have to
what
admit
purpose will be served?
I have to admit one thing, lordship. I came to this school or in service only on 10th of March
No,
2017.
therefore, you see,
Thereafter, lordship, according to this.
no,
lordship,
Mr. Deka, you see, your name is not there in the year 2017 and 18. And their requirement is that your
17.
name should be there.
Yes.
If your name is not there, how can they consider it? If that is the only criteria?
That is why I am before on 3rd of 11, I am before the authority prior to issuance of this notice. But on this represent also they have not taken decision. Why they have not captured my name? They because
No, you
according
see,
to
that is the duty of the Samagra Shiksha.
Samagra Shiksha of it and the school authority.
That particular school authority, they should forward his name, where he was working.
Yes, because the last instruction, it specifically says the school management committees manage the appointment of documents, the attendance register, all these things will be provided by the school authority only. Here it is not a case that it is my duty to capture my name. I cannot capture my name individually. It is the
No,
head of.
but Mr. Decker, you are admitting that your name is not there in the
Not there.
2017.
I'm admitting that.
And their requirement is that your name should be there.
There,
Then what will they verify?
meaning thereby, although I am working or although I have been appointed on 10th of March 2017, their case is, although I have been appointed on March 2017, since my name is not captured under UDIAS in the year 2017, you cannot apply. That is their case. And the Supreme Court lordship says that the in-service candidates, they should be appointed on or before 10th of August 2017. But here it is a case that because of the lapse of the other authorities, not me, either it may be the school authority, DO or block, they have not captured my name. Because of their lapse, now I am depriving. That is why I am before the authority on 4th of 11, 2025.
That is vague and not whether that can be considered.
No, I am not again. Prior to issuance of this notice, I am before the authority. Let's kindly see page 31. The representation was submitted on 4th of November. And this notice came on 27th of November.
Mr. Decker, you see, this mission director Samagra Shiksha
Abhijan.
Yes, Assam is not before this court now.
No, I am making a party. Notice served also. The last time they appeared. No, notice about because we have started, they have been standing council. Yes, mission director, annex respond number 3.
It can be given, that also I am not aware, because
No,
it
no.
is lost in a year, in a.
No, there is a receipt there, lordship, 4th of November. Wow, 4th of November, it is the seal of the Samagra Shiksha Abhijan. Seal is, okay, kindly see the page 31. It is not backdated.
No, I'm not that. But a dice code can be entered at a later on in the 2017 dice code can be entered in the year 2025. I have doubt about this.
That is why lordship take.
No, is the director elementary education or secondary education is the mission director?
No.
Mission director is different.
Separate entity. And today is announced that lawsuit, whether the ineligible candidate can be allowed to
No,
Because it
although,
participates.
although today is the
No,
last day, I have-
allowing or disallowing, that question does not arise. But this representation has to be disposed
but
of.
I
then.
am before this court on 26th of November.
Depends on submit before.
I am before this court on,
Elementary lawsuit.
No, this is Director Samagro Shiksha Assam.
Lordship is
Annexer.
all they are responding because, no, response.
But they are, they are not a authority who advertise lawsuit, this particular address in lawsuit.
That is
They
right.
have published.
The director will consult with the director, mention director.
And today is the last date of submission of the, we have extended it till today. And assessing it, they have not published this or advertisement, it is the elementary, director elementary, they have published it. And the notification issued by the director elementary itself. And today at this hearing in lawsuit, whether that can be allowed. Because similar cases were already been rejected by the honorable court.
So what I am on the, let's see, as per this instruction, there is a requirement. These documents should be supplied by the school authority, because if we go by this letter, appointment and joining is required. School management committee minutes is required, then attendance register is required, whether I receive salary or not, this all things should be provided by the school authority.
These are provided by the candidate lawsuit, suppose in earlier education is concerned.
How can I
They will
provide?
recommend that if
Yes.
candidate when he was appointed.
No,
the
appointment of-
should have been with his or her office.
Appointment already there, I have NA, but so far the register is concerned, the minutes is concerned, the authority is the school authority, that is why I made them party. It is a party lordship.
But they are not before the court now.
Notice is not issued because this case was come up on 26th of November.
Mhm.
So taking note of the urgency lordship, my learned friend was directed to have instruction and fix the matter today. Until that lordship, my application is kept in abeyance. No decision is taken.
And because.
Today is also the last day.
Is today. In my submission, there's not a similar kind of petition has already been rejected by the honorable court in the coordinate bench. It is in appeal, there is no stay. And so.
No, that's all right, but this representation is a file prior to the notice.
Notice.
Prior to notice, what are lawsuits?
Why this representation has not been disposed of? And who represent this mission director?
Mission director, we do not, it is a separate.
B. Chaudhary.
P. Nayak, B. Chaudhary, they are there. That is not before us, lawsuit. This revision was submitted before the SSA.
In presence of SSA, this application representation may be disposed of. Let the matter fix on Wednesday. Until then, the earlier interview may be continued.
But in this.
Captain Away. No, I am not against this or staying the process or hold the process. There is no such order. Only it is only in respect of me that you don't take decision regarding this petitioner.
But suppose lawsuit that regarding UDAS, it will take time for that, whether this intermediary will continue for long lawsuit.
No, may not be till
If today the recruitment process is, last date is for submission.
Lordship, then they make an observation that this order is only in respect of this petitioner only. And no will prejudice. Only in respect of this petitioner. Only one petitioner also. Otherwise, Lordship, out of 156 code, 113 and 103.
Similar cases were already been rejected by the honorable court with a cost of 10,000 lawsuit. This matter may can be rejected lawsuit. It cannot be considered in terms of the honorable Supreme Court direction lawsuit. There is a specific direction by the honorable Supreme Court that those who were prior to 10/8/2017.
okay, you produce the decision of the Supreme Court before
There
that.
in that order, I have given that.
No.
Yes.
You produce the original order of the Supreme Court.
That original order, we don't have the, that's, we have the photocopy on the,
Pardon?
we have only the photocopy lawsuits.
Yes,
Yes.
that order.
That photocopy.
Here only reference is there.
Photocopy, yes, lawsuits.
We'll see what was the direction.
I think Lordship, facts may be different also.
You produce it on Wednesday, till then this interim order shall continue.
Wednesday, could you?
Heard Mr. Decker, Learned Counsel for the petitioner. Mr. SMT Siste, Learned Standing Counsel for the respondent in secondary or elementary?
Elementary Lordship.
Elementary Education Department. None appears for the respondent in
SSA only Lordship. Because so far respondent 4 is
respondent
concerned.
number
What is,
3.
yes, 3 not appear.
Respondent number 3. Though, according to Mr. Decker, notice was served upon them.
It is causally the name is shown Lordship.
Accordingly, it is provided that SSR list the matter on Wednesday, till then interim order passed
On 27/11/2025. So for the present petitioner is concerned,
Oh,
I'll
really?
continue.
Obliged.
On that day, Mr. Sisti, you produced the
I've-
Supreme Court order,
Yes. In fact,
entire order.
Yeah, I have printed out, Lordship, invariably the last pages were not printed out. So I couldn't.
On Wednesday, you produced it.
Yes.